admission item number 1.
My lord, the question is framed at page 8, my lord. Whether in the fact and circumstances case and in law, the IT is correct in holding the service of notice by speed post on the last known address available with the department would not amount to valid service as per the provision of IT Act. Whether in the fact and circumstances case, the IT is correct in holding that the appearance of the representative of a person in the proceeding subsequent to the service of notice at the last known address would not preclude the person from claiming that notice was not served on him. Whether in the fact and circumstances case, the IT is correct in holding that the notice was physically served on the SSC is invalid.
No, did he give the information on change of address, or he did not?
Well, the tribunal order, page number 14, the notice dated 6/3/2019 and date of compliance was given on 18/3/2019. On 23/2019, one Mr. Uttam Kumar, claiming to be the staff of the SSC, by letter dated 18/3/2019, intimated that the principal CIT that his employer being the SSC is in judicial custody and is unable to attend the notice immediately and sought reasonable time of 1 month to organize the substitution of the data. Madam, the Delhi High Court judgment and allow the High Court judgment is
We are given the
Delhi High Court judgment, allowed the High Court judgment is there, where notice is valid. And
No, my question was whether the change of address was informed to the department or not.
well, section 292BB also, notice deemed to be valid in certain circumstances. Where an
was
SSC
this-
appeared,
Sir, just answer the question. Was this a case of change of address?
is involved in GST fraud case, my lord. Is in
Mr. Chimanka, only
Yes.
question you have to answer is
yes.
whether the changed address is informed to the department by the SSC or not. If at all, when?
No,
Not given.
he is in jail custody. How is he given the address?
No. Once the remark is, what was the remark? What is the facts here, sir? Tell us the facts. Don't talk about GST fraud and all. Facts relevant to the service of notice.
What does your records show?
Yes, record shows that that
Assessment record you have?
yes, not assessment, but the assessment order is there and
No. Assessment order. Is there any,
I'll call from the record. That
is there any observation with regard to service of?
Just come to page 20 bottom, sir. At least the fact remains, at least from the 5 lines from the top, you can start. Now the facts in the present case, just read from there. Page 20, 5th line.
in the case of individual,
No. Now the facts in the present case show.
the
Page
fact
20.
remains that at that point of time, the SSC was under judicial custody. But when Sri Uttam Kumar, claiming to be an employee of the SSC, has responded to the notice, the principal CIT himself categorically held that the said Uttam Kumar does not hold the power of attorney to represent the case SSC. Learned principal CIT has been communicated by letter that the SSC is in judicial custody. When an individual is in judicial custody, any notice on such individual can be served on him only through the superintendent of jail, when the individual is lost. One should keep in mind that once the individual is taken under judicial custody, many of the constitutional right stands curtailed. Nothing stops the principal CIT from communicating the notice to the individual in jail. Once he is intimated that the SSC in jail, the principal CIT was aware the SSC is in judicial custody as on 23/2019. He had adequate time to serve notice on the SSC in jail through superintendent of jail. Instead of this, the principal CIT proceeded to issue order under section 263. He failed to serve notice on the SSC, even though he has informed of the judicial custody of the SSC. One must also keep in mind that when the SSC is in judicial custody, his address during the period of judicial custody does not change, and it cannot be said that the SSC is absconding. The second condition that the SSC should be given an opportunity.
That's relevant facts, sir.
Yeah.
Correct. And still you don't choose to.
Section 292 may kindly see.
Appeared at the
BB.
to authority with regard to his whereabouts.
292. Where an SSC has appeared in any proceeding or cooperated in any inquiry relating to an assessment.
1 minute.
292 BB.
Where has he appeared? Where an SSC has appeared in any proceeding?
He has appeared through Mr. Uttam Kumar. Is
No, he
represented.
doesn't hold a power of attorney at all. He has not appeared.
It can at best be considered that he has intimated about the whereabouts of the
Yes.
assessee.
Yes.
So you could have very well served on him, taken steps to serve on him.
Just my lead 290, where an SSC has appeared in any proceeding
Ah.
or cooperated in an inquiry relating to an assessment or reassessment, it shall be deemed to that any notice under any provision of this act which is required to be served upon him.
So this has to be strictly interpreted.
Yes.
This SSC is in jail.
Yes.
So he has not appeared.
He
As
has not-
simple as that. If that said where an SSC or his constituted attorney has appeared.
Yes.
It does not say that. Section is very clear. The SSC himself or the SSC itself has to appear. This is like waiver, acquiescence, that principle this is. That is, you have yourself appeared.
Yes.
Now can you say you're not aware of the proceedings? That's the principle here.
Last, the close, they are A, B, C. Taking the objection in the proceeding in inquiry under this act, that the notice was not served upon him in time, or served upon him in an improper manner.
It's not served upon him at all, sir.
Yes.
He's in jail. You are aware he's in jail, yet you do not choose to send it to the jail superintendent. As simple as that. None of these decisions is in a situation where the person is in jail.
Yes.
So all these decisions will not help. That's why we kept asking, is this a question of change of interest? It's not that. The person is in jail, you know he's in jail, and still you do not.
Well, let me take instruction.
For
One
what?
week time. 1 week time, you can do it.
For what? These facts are very clear. These facts won't change because of 1 week. The short questions ought to be urged with relief in the present appeal directed against an order dated 15 June 2022 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, allowing the SSC's ITA numbers 170 to 175 /CTK /2019 for the assessment years bracket AYs 2009-10 to 2015-16 is whether service of notice by speed post on the last known address amounts to valid service as per the provisions of the Income Tax Act 1961 bracket Act. The background facts for the purpose of the present appeal was that there were search and seizure proceedings under 132 of the Act, Section 132 of the Act, in the case of Messrs. Shivam Minerals Limited and Group on 24th September 2014. Full stop. On the basis of the seized books of accounts, the case of the respondent SSC was taken up for scrutiny for AY 2010-11. Full stop. It stated that during the course of search, certain incriminating documents were found. Thereafter, assessment proceedings under Section 153 capital C read with Section 143 bracket 3 for the said AY was completed, making an addition of rupees 961,240 paragraph. Subsequently, case of the respondent SSC was picked up under Section 263 of the Act, and it was concluded that the original assessment order under Section 153 capital C was erroneous and prejudicial to the revenue. Full stop. In the proceedings under Section 263 of the Act, notice dated 6th March 2019 was issued for being served upon the SSC at his last known address. Paragraph. Before the Principal Commissioner of Income Tax bracket PRCIT bracket conducting the proceedings, one Shri Uttam Kumar, purportedly a staff of the SSC, appeared and informed the Principal CIT that the SSC was in judicial custody. Full stop. Instead of directing notice to be issued to the SSC through the superintendent in jail, the Principal CIT treated the appearance of Shri Uttam Kumar as sufficient service of notice on the SSC in terms of Section 292 BB of the Act, and proceeded to pass his order under section 263 of the Act, revising the assessment proceedings for AY 2010-11. Paragraph. A further addition of a humongous sum of rupees 789,03,576 on account of unexplained receipts was thereafter made without hearing the SSC. Paragraph. It is in the above background, it is sought to be contended by Mr. Chimanka, learned senior standing counsel to the department, that in terms of section 292 WB, the appearance of Shri Uttam Kumar, a staff of the SSC, should itself be treated as appearance of the SSC. And once the SSC has appeared, he no longer claim that he was not served with a notice. Paragraph. The court is unable to agree with the above submission. Full stop. Section 292 WB reads as under reproduce. Paragraph. The above provision in a taxing statute admits only of strict interpretation. Full stop. If the legislative intent was that an SSC or his authorized representative could, the appearance of the SSC or his authorized representative was sufficient for the purposes of presuming service of notice, then there should be an express provision to that effect. Full stop. The provision, on the other hand, only talks of appearance by the SSC and not an authorized representative of the SSC. Paragraph. Factually, however, as noted by the ITAT in the impugned order, Shri Uttam Kumar was not an authorized representative of the SSC. Full stop. He was simply the staff who appeared to inform the principal CIT where the SSC could be located. Full stop. This was the jail in Visakhapatnam. Full stop. Despite being informed that the SSC was in judicial custody, the principal CIT did not make the effort of having the notice served upon the SSC to the superintendent of the concerned jail. Paragraph. This court concurs with the observation of the ITAT in the impugned order that a person in judicial custody is deprived of many of the constitutional rights which he could otherwise exercise. Full stop. Any officer of the government, including a principal CIT, should be conscious that once information is received, the person to whom notice is to be served is in judicial custody, then an appropriate order should be passed requiring service of notice on such person to the superintendent of the concerned jail. Full stop. This is the bare minimum requirement in law. Full stop. With the principal CIT having failed to do so, it is not open to the department to contend the mere appearance of a staff of such person in judicial custody before the principal CIT should be taken to be the appearance by the noticee / SSC himself. Paragraph. Two decisions have been relied upon by Mr. Chimanka in support of the plea that in the facts of the present case, it should be taken that the SSC was properly served. Full stop. The first decision, that is Commissioner of Income Tax, Delhi versus Matsi Films Private Limited, 2008-301 ITR 69 Delhi, was in a fact situation quite different from the one on hand. Full stop. There the question was whether for the purposes of section 27 of the General Clauses Act 1897, service by post should be deemed to have been effected properly by properly addressing, prepaying and posting by registered post the letter at the last known address of the SSC. Full stop. Since it was shown that the notice was properly served at the address available with the department, the court proceeded on that basis that there is a presumption of proper service of notice. Full stop. That case did not involve the SSC being in judicial custody which fact is within the knowledge of the department, and yet no notice is served on the SSC while in judicial custody. Paragraph. The second decision cited, that is Commissioner of Income Tax, this is Privilege Investment Private Limited, 2017, 395 ITR 147, also did not involve an SSC being in judicial custody. Full stop. Neither of the decisions, therefore, help the department to contend that the ITAT committed any error in declining to accept the plea of the revenue in the present case. Paragraph. No substantial question of law arises. The appeal is dismissed.
Item number 2.
Same.
Same, different assessment here.
This is what, which assessment year? 78? That was 10, 11, and this is
Figure will change.
11, 12.
11, 12. All right.
Figure will be changed to 744, 77, 979. Figure. The creditor figure which has been added will be changed in this assessment.
All right. All right. Now there will be some 4 more appeals, similar appeals.
No, 2 appeals
Only
only.
2 years.
2 appeals.
All right.
Because all 3 appeals are below monetary limit.
I thought as much.
Supplementary list item number 3.
May I please? Here, Millard, I have challenged the revisional order annexure 1 and the circular annexure 2 issued by the Commissioner of Sales Tax.
Hmm.
Here, the fact is that the petitioner has filed real return at the time of initial filing within the time, but thereafter, Millard, just to file revised return, but due to Millard, new act came into force, Millard is not able to file the revised return in time. However, in the next, Millard, the provision is says, Millard, if you improve the tax and the turnover, then we can file in 33 subclause 5 of the act revised return. However, Millard, there is no, the portal has not accepted to send it through the postal.
No. Give us some idea. What was the last date which you had to file, and when did you try filing it?
Millard, I have not filed in within time, Millard. That is admitted fact.
That within time is one very broad thing,
Yes,
sir.
Millard. I'm just.
What was the date by which you had to file, and when did you try filing?
Yes. Section 33, Millard.
Sir, give us
Oh,
facts first.
yes.
What was the date by which you had to file a return?
What is the period of
Millard,
return?
for the Millard, each quarter, Millard, next month.
Sir, I don't have facts at all. Unless you give me facts, I can't appreciate the point you're making.
You wanted to file a revised return in respect of quarter ending
Yes.
March 2015?
June 14,
true?
September and March 15. June
September,
14 to March 15.
September 14, quarter.
Quarter ending June 14 to March 15. That is 4 quarter.
Three quarter.
4 quarter.
Huh.
4 quarter I have to
You wanted to
revise. But Lord, we could not revise the return.
Sir, tell me the date by which you had to file, sir.
I'm not just.
I'm a bit dull.
Once,
You have to tell me.
Once.
Sir, please. I want him to answer,
Yes,
not you to answer. Justice Raman is doing all the homework for you. I don't want that because I want you. You are the lawyer for the petitioner. You should have the facts.
Yes.
Yes. We can't even supply we should not be supplying facts. You should supply the facts to us.
Not.
You do your homework and come.
Yes.
Without laying factual basis, no petition will be argued.
Yes.
Yes. Counsel for the petitioner seeks some adjournment to bring on record the proper facts at his request list on July 10.
Item number 4,
Same.
Same.
item number 5, supplemental list item 5,
None appears discussed.
item number 6,
It's not personal.
Not dismissed is not raised.
item number 7,
So this is the matter arising out of that Madhuri Patil case. Lord, your lordships has already decided a case, but here the 2009 state level scrutiny committee order was under challenge, and my lord, no counter was filed. But after matter came up after 14 years of dispose of, your lordship will find digressing from the points and whatever from the diversion from the points, but only on the basis of surmise the order has been passed. And that is the impugned order, page 14. My lord, the background of the case is that the petitioner is a scheduled caste and a Pana, and he has obtained the certificate in 91 and also availed the service. And he continued as such. Till now also he is not availing any other community benefit. And my lord, the case was that after obtaining the scheduled caste certificate, then in 2009 a scheduled tribe certificate was obtained and he has taken the benefit. But he has not taken the benefit, and he has also stated in the so-called reply that was why a conspiracy somebody has introduced because of the community right during that time, and I have not availed any benefit, and also he is not also Christian. That is also as per the inquiry report. And he has given in the writing that the evidence should be given to me and all documents should be given to me, as your lordships decided in earlier case also that I should be given opportunity of cross-examining them. Nothing was given. Only the inquiry report was based on, and the final order was passed as per Annexure 5 of the writ petition without applying any mind. But in this regard, your lordship has already passed an order, judgment, that I am giving that, my lord, also can say. And recently also, your lordship will find that, my lord, page 51, he is still scheduled caste. He has not availed any benefit. That your lordship will find in 51, page 51.
Oh, this is something else, sir. This is a new variation. The man is scheduled caste and he tries to project himself as scheduled tribe. That's the whole problem.
Yes.
Just come, let's get to the facts now. Page 18. What the inquiry report found?
Page 18.
Whereas the state level scrutiny committee.
Yes, Lord.
Just read
State
that.
level scrutiny committee, that is Lord.
Third paragraph, sir. Whereas the state level scrutiny committee duly considered the IO's report.
My Lord, that time.
Page 18, sir.
Yes, my Lord, I am there. 35.
Is 36.
36.
Your reader.
Yes, my Lord. Lordship, kindly see. My Lord, I am reading. Whereas the DWO, Kandamal,
The
has
state
pub-
level scrutiny committee
that is the
duly considered the second para from the top.
I am just coming, my Lord. My Lord, your Lordship will find no objection have been received by the
Sir,
chairman.
kindly read what I'm asking you to read, sir. Then we will read what you want us to do.
My Lord. My Lord,
My lord, I may be supplied a copy. I have been party. We have not sought.
So come to this page 18.
Well, that is page, running page 36.
No, for us it is 18. I don't know, whatever that is.
This is in
Writ
writ
petition,
appeal
sir,
page
writ petition.
36.
Writ petition page 18, I don't know.
Oh, page 18.
Writ
Oh,
petition of the old writ.
yes, yes.
Single bench,
My-
honorable single judge.
Whereas the state level scrutiny committee duly considered the IA report, the so-called reply of the alleged person as well as the written statement made before the committee during personal hearing on 21/4/2009 and other relevant records, and unanimously held that the allegation of the caste certificate.
No,
Fake caste certificate. Fake caste certificate.
that adjective is the critical
Yes,
adjective.
I'm reading. Allegation of fake caste certificate in the case is a fact due to the following reasons. Well, that it is revealed from the report of the investigating officer that the alleged Lakshmikant Malik, so and so, of village Green Body,
So and so.
yes, so and so, belongs to Pana caste, scheduled caste by caste and Hindu religion. It does not belong to the Kandha tribe ST. As recorded in the ROR, Khatyan number 5, issued on so and so, the caste of candidate in Pana, this ROR stands in the name of Andrea Malik, son of Paul Malik of Moja Greenbody. Since the genealogy and the land record reveals that the ancestral forefathers are Pana by caste, their successor will automatically be Pana by caste, not Kandha. The genealogy is so and so. In the year 91, Sri Lakshmikant Malik collected a caste certificate from Tahsildar Daringbadi as Pana by the RMC number so and so, issued on 4/4/92. On the basis of this certificate, he had joined as a Sikha Karmi under Daringbadi block under SC category, and he became regular in the year 1994. Fraudulently, he has made a collect under caste certificate from Tahsildar Daringbadi in the year 2006 as Kandha by the RMC case number 7. Well, here, well, let's allow me to pause for a moment. Well, this Kandha certificate, he has denied in the so-called reply that I have not availed any benefit, and this Kandha which is given also, that has been during that conspiracy because of the riot, communal riot. Well, at that time, the people, they were only, because your lordship kindly see that Madhuri Patil case, well, that is on the occasion that many tribal people, and though they are Christians, but they, as the tribal people, they are getting benefit. But here your lordship will find I have given in the so-called reply that that certificate I have not availed any benefit. Still I am that certificate, scheduled caste certificate I have got, and your lordship will find recently also the promotion has been given as a scheduled caste, and that is page 51.
No, I think I request you to continue reading para D. We'll know
As
what you
per-
have done after that.
As per report of the IO and gradation list of DIF schools, Baliguda, his name is enlisted in serial number 403 under ST category. Yes, which he has agreed and has signed in the year, and that.
So this statement,
He
shows
has-
the
he has-
submission you made is
Malad, he has before this.
Whatever he is saying that
Just a minute.
contrary to the record.
Just a minute.
He
Before
has
this,
availed the benefit.
just a minute. Malad, your lordship will find from the so-called that he has applied, that this has been wrongly done, you cancel it. That has been cancelled also. That fact has not been considered. Your lordship kindly see. And I have not availed any benefit, nor I am also Christian. That is also as per the inquiry report. Your lordship kindly see. The so-called reply I have given, well, at that time, batch of cases of 2009 also concluded with the judgments remanding the matter. That division bench judgment I have given. Unfortunately, the case remained pending. If your lordship kindly see my so-called reply. So-called reply for a moment. Alert. Kindly see so-called reply. Page 32. The lordship kindly see page 32.
Yes.
stated here. That my lord, I am reading the second paragraph. That in their statement, the witnesses have stated that I have got my service as the teacher in SC category by obtaining caste certificate from Tahsildar Daringbadi, but after being appointed, I have procured another caste certificate as Kanda to get immediate promotion as ST. Though it is a fact that I have procured a caste certificate in SC category, but the subsequent caste certificate as Kanda is not procured by me fraudulently to get under promotion, as I could have got promotion in SC category also. Hence, it might be a manipulation by impersonating me to get under. And
third variation now.
This is another variation in your.
You are not arguing. Anyway,
pardon me?
what he is saying, what you are reading out now, his reply is something beyond what you are arguing also. He is now saying,
My lord,
"Sir, that is not me. Somebody has impersonated and got that certificate."
And your lordship, kindly see the next subsequent paragraph. My lord, what is the object of the Madhur Patel case? Some people are getting the benefit as Christian, and the inquiry report says
No.
he is not Christian.
Not Christian. Some
Not
people
Christian.
are getting undue benefit by producing scheduled tribe certificate, fake certificate,
And lordship,
and that is the subject matter of the investigation
And
by order of the Honorable Apex Court.
I am just this said caste certificate in ST category. Rather, I have written to the DI of school Baliguda to correct the mistake as SC in gradation list. Hence, the allegation of procuring the caste certificate in byte case number does not arise, as I have already procured the SC certificate and got appointment on that basis, taking advantage of the present communal environment on the background of 2 riots in Kandhamala. This allegation has been made. Otherwise, there is no foul play. And your lordship, kindly see, this is fortified from the documents. Lordship, kindly see, I have been promoted recently as also scheduled caste. No benefit I have given taken, that is page 51. Last for a moment, kindly lordship, kindly see. For a moment, 51, page 51. Page 50, it begins. My lord, lordship will find page serial number 20.
Yes.
My lord, here, Lakshmipant Malik, so and so, as a SC, is still continuing as SC.
Yes.
He is not ST also. And my lord, I have also given that I have not been given opportunity of, my lord, cross-examining the witnesses. I have not been given proper opportunity of hearing. That is why at that moment, my lord, that judgment came. Unfortunately, my case could not be done. So that is why otherwise it could have been remanded. And recently, lordship also passed the order. I have given that copy of the order, my lord, of your lordship.
Apno case re jota.
In that, my lord,
That is a
in
different- that
your
is a
lordship,
different matter.
no, in that your lordship found that in the ROR also I am still SC. If I have not get benefit anything from as a scheduled tribe,
My lord, in that case, there is no case of multiple certificates. Here, a same person, 2 certificates, that itself prima facie proves that you have fraudulently obtained either of the two. That is,
my lord, that may be, my lord, as I have stated, but I have not availed any benefit of a scheduled
that
tribe.
is a different thing.
Then, my lord, how does it differ?
No, sir, that's not correct. Come to that same page which we were drawing your attention to.
Pardon, my lord?
Come to that same page we were drawing your attention to. It's not correct what you're saying.
As ST candidate, he got the promotion on the
That's
basis
right.
of the second certificate.
Come to
And-
that page 18 bottom.
Page 8.
Yes.
Page 36.
In the gradation list of DI of schools, Baliguda, his name is enlisted at serial number 403 under ST category,
ST candidate.
which he has agreed and
How
signed.
is
in the-
saying this, I don't understand.
That has been cancelled, my lord. Had I been ST,
This is
Well,
these are kind of cases where merely because subsequently you set right the record, the fraud committed cannot be wiped away. Sir. That's the whole problem.
well, that may be in a different context, but so far the Madhur Patel case
It's like
objective
getting
is
2
there.
ID cards.
Pardon, my lord?
Getting 2 ID cards and then saying, see, I'm not using the second one.
No 2 ID
I'm-
cards
I've
for
got-
the same.
I kept it in my pocket, but I'm not using it.
But your lordship find the government record.
Yes.
My lord, the government record shows recently that still I am continuing as SC. That I have shown to your lordship. So in view of that, a person will be deprived of his livelihood at the end of this service stage. My lord. That your lordship kindly consider. If he has not availed that benefit of the scheduled tribe.
The fact that he applied and got a certificate projecting himself as a tribe when he is in fact a scheduled caste itself is a serious problem. Very
If your
serious
lordship
problem.
will see the last page, findings of the SLC, categorically held, he has taken review government
See, this is the
salary.
question of honesty. Really a question of honesty.
That
But-
is,
But my lord, your lordship kindly.
And you're a government
appreciate.
servant, you're a government servant.
But-
Correct?
My lord, that may be a misconduct, but I have not got
What
a
is this
benefit.
maybe? What is this maybe?
My
That's the whole
lord,
problem.
but my
Now
lord,
your own misconduct is the problem. Sir.
but Madhuri Patel case, lordship kindly see, the objective is that the Christian people are getting
no,
the
no,
benefit.
Christian, not
As scheduled
Christian
tribe.
people.
But
Why-
here I have not got any.
Why he is not correct.
Also a Christian, my lord. That is also inquiry report says.
That is not at all for Christian people. That is for fake caste certificate. That is the subject matter of investigation.
But first,
By the SLC.
But-
And admittedly, you have got a fake
No,
certificate in 2000. That
But
is the
yes,
finding
sir,
of it.
Every defense is, sir, I'm not using that fake certificate.
yes, I have not got any benefit of.
Which
Not
is
that
contrary
you-
to the
Not that you did not get it. You
No,
said,
no,
sir, I got
contrary
it,
cannot be, my
but I
lord,
did not use it.
my lord, contrary cannot be because the last record shows your lordship, so that page 51, I am scheduled caste.
All,
I got the benefit as scheduled caste,
yes, yes,
not as a scheduled tribal.
all,
So that is, my lord,
all. The challenge in the present writ appeal is to an order dated 10th January 2023. Sorry, yeah, passed by the learned single judge.
my lord, may I submit one thing?
Dismissing writ.
Can it be sent for de novo inquiry in view of
No,
that
no.
division bench judgment?
They've done a very thorough job, sir. Dismissing writ petition civil 12863 of 2009, filed by the appellant, whereby he had questioned
डीओ को कम्युनिकेट करते हो अपने
an order passed
स्कूल एंड मासिक
They do.
on 29th July 2009 of the State Level Scrutiny Committee, bracket SLSC, bracket, on the issue of the appellant having obtained the fake caste certificate in terms of the allegations available with the District Vigilance Cell, bracket DVC, bracket Kandamal, for inquiry. Paragraph. The background facts are that, admittedly, the appellant belongs to the Pana community by caste, that is scheduled caste, bracket SC, and is a Hindu. Full stop. In the year 1991, he collected a caste certificate from the Tahsildar Daringabadi, which showed him to belong to the Pana caste. This caste certificate was issued on 4th April 1992. Full stop. On the basis of that certificate, the appellant joined as Shiksha Karmi in the Daringabadi block, and his services were regularized in 1994. Full stop. It appears that subsequently, in 2006, he applied to the Tahsildar Daringabadi to be issued a caste certificate showing him to be a scheduled tribe, bracket ST, that is Kanda. Paragraph. The report of the investigating officer who conducted the inquiry revealed that in the gradation list of the directorate, District Inspector of Schools, Baliguda, his name was listed at serial number 403 under the ST category. Full stop. He had signed the list. Thereby accepting the correctness of that entry. Full stop. The SLSC issued a notice to the petitioner. To which he filed a reply received by the SLSC on 11th February 2009. Stop. On 21st April 2009, a hearing was conducted with the SLSC in which the appellant appeared. Full stop. He stated before the SLSC that he had nothing more to state than what he had already stated in his reply. Full stop. Interestingly, in the reply, to the show cause notice, while he admitted to getting a caste certificate in the SC category, he sought to contend that the subsequent certificate showing him to be Kandha, open quotation, might be a manipulation by impersonating me to get undue advantage by any outsider, unquote. Full stop. The above contention of the appellant was disbelieved by the SLSC for the simple reason that the report of the IO showed that the gradation list of DIF schools, Balikuda, showed the appellant's name at serial number 403 under the ST category. And he had in fact agreed and signed in the said list, thereby getting an accelerated promotion. Full stop. The inquiries made by the IO also revealed that the genealogy and the land records of the appellant revealed that his ancestors were also Pranabai caste. Full stop. Therefore, there was no question of the appellant seeking to project himself as Kanda. Stop. The SLSC correctly observed that, open quotation, the involvement of the then Tahsildar, Shri Basudev Sahu OAS, in procuring such fake caste certificate to the alleged person cannot be ruled out. Stop, unquote. Mr. P.K. Mantil, under senior counsel for the appellant, contended that the appellant never made use of the aforementioned certificate obtained in 2006, which showed him to be an ST, that is Kanda. And even the most recent gradation list of 2022 shows him as belonging to the SC category. Full stop. In other words, he urged that the appellant had never taken advantage of the subsequent caste certificate obtained by him in 2006. And therefore, the impugned order of the SLSC to initiate criminal proceedings against him for obtaining a fake caste certificate should be set aside. Full stop. Paragraph. The appellant, being a government servant, has to be held to the highest standards of conduct. Full stop. Having obtained a certificate showing him to be SC, belonging to the Pana caste, way back in 1991, and joining as Shiksha Karmi on that basis, there was no justification whatsoever for the appellant in 2006 to have again applied for another caste certificate showing him to be an ST. Full stop. This very act of applying for and obtaining another caste certificate, wrongly projecting himself to be an ST, was sufficient to attract the provisions in the applicable rules governing misconduct of government servants. Full stop. It is entirely besides the point whether the appellant made use of such caste certificate or sought reversal of any benefit he may have obtained on the basis of such caste certificate after the fraud came to light. Full stop. It is an undeniable fact, evidenced by the records, that in the gradation list, as noticed by the IO, the gradation list of DIF schools, Baliguda, as noticed by the IO, his name was shown enlisted at serial number 403 in the ST category, and he had in fact signed that list in acceptance of its correctness. Stop. It is futile for the appellant to contend, therefore, that he did not make use of the fake caste certificate obtained by him. Paragraph. Mr. Mohanty then placed reliance on a judgment dated 17th October 2022. This is not reported, is it? Passed by this court.
No, it is a
in writ appeal number.
I know it's a reported judgment.
Anyway, writ appeal number
1994 SCC.
No, all right.
No, this one.
In writ appeal number 334 of 2017, bracket Michael Nayak.
This honorable court start. Honorable Justice B. Gopal Gowda. That is, you are relying that, or you are relying Madhuri Patil?
Full stop. There, the SLSC held the said appellant to belong to the Pana Christian community, and accordingly held that the caste certificate issued in his favor, declaring him to be an SC, was obtained fraudulently. Stop. This court found that there was no factual basis for the SLSC to come to such conclusion, and that its order, open quotation, throughout proceeds on conjectures and surmises to come to such a conclusion. Paragraph. In the present case, however, the SLSC appears to have followed the due process of law in calling for an inquiry report, furnishing the appellant with a copy of that inquiry report, issuing him an SCN, allowing him an opportunity to reply to the SCN, and then having heard him. Full stop. In other words, there was complete compliance with the principles of natural justice. Full stop. This was what was envisaged by the judgment of the Supreme Court in Kumari Madhuri Patil versus Additional Commissioner Tribal Development, AIR 1995 SC 94. Full stop. Consequently, the court is not persuaded that the decision in Michael Nayak supra applies to the facts of the present case. Full stop. Further, the court is also not persuaded to accept the plea of Mr. Mohanty that the matter should be sent back to the SLSC for a fresh hearing and a fresh inquiry. Full stop. the court is satisfied that there has been a compliance with all the requirements of the principles of natural justice in the present case. And therefore, the matter does not need to be sent back to the SLSC. Paragraph. The court is not satisfied that any error has been committed by the learned single judge in dismissing the appellant's writ petition. Full stop. The writ appeal is accordingly dismissed.
Item number 8.
Item number 8, no instruction.
No instructions dismissed.
Item 9.
May I please, your lordship? My lord, while placing the matter, my learned friend appearing with the opposite party number 5 stated, lordship may recall that stay is continuing before the endowment commissioner in the connected matter which is subject to dispute here. But in fact, I have gathered that no interim order is there. This order was operating for last 10 years, my lord. And your lordship had targeted the matter to be over within 4 months, my lord. And there is another OA is pending, that is OA 3 of 2013. So what I pray, my lord, your lordship, both the matters, I may be allowed to intervene in both the matters. That is another OA 13 of 2013. Sorry, 3 of 2013. And if possible, your lordship, that interim order which was continuing here with regards to the status quo may be continued.
I am for the opposite party.
5.
5. I have objection to this, my lord. Because lordship may kindly have a glance on the paragraph 3 of the miscase, the IA, which has been filed yesterday. I am reading out.
Right.
That the present writ application was allowed by order dated 11/1 to 2023 by this honorable court with the following observation. At the first paragraph of the order, it is informed by the opposite party number 5, that means me, that the proceedings are already pending before the commissioner endowment in OA number 86 of 8. It's a fact, it's still pending. Secondly, this proceeding was dropped on 16/8/2010 by the Learned Commissioner Endowment, Odisha, as this proceeding was quashed by this honorable court by WBC number 712 of 9. Against that order, state has gone to Apex Court, and Apex Court has already remanded the matter to Learned Endowment, and the 86 is reopened.
Oh, I see.
And status is continuing.
Where is the Supreme Court order?
Yes,
You have it.
I have one copy. Yesterday he sought me a copy. I have only one copy. And the 86 status is continuing till date. At tomorrow is the date.
Maybe you are not aware of it.
In any case, your lordship, OA 3 of 2013 is also pending.
That's right.
That your lordship may indicate.
All right.
Status quo ଅଛି ଏଥିରେ Supreme Court ରେ
The present application
Section 7, the person from the executive
by Shri Devi Prasad Sahu. The intervener, is it?
Yes, my lord.
petitioner and interview.
Petitioner before lordship.
That is the petitioners. Seeks modification of the order passed by this court on 11 January 2023. Full stop. It is stated that a statement was, it is submitted that a statement was made by opposite party number 5 that OA number 86 of 2008 was pending before the Commissioner went out, when in fact it was quashed by this court by an order dated 17 July 2009 in Petition Civil 712 of 2009. Full stop. It is stated that there's only one other application, being OA number 3 of 2013, pending before the Commissioner Endowments, Odisha. Stop. It is accordingly prayed that while taking note of the above facts, this court should also allow the present petitioners to intervene in the above way and continue the interim order that was prevalent. Full stop. Counsel appearing for opposite party number 5 has produced before this court copy of an order dated 21st September 2016 passed by the Supreme Court of India in Civil Appeal number 7272 of 2013, bracket State of Orissa versus Urmila Builder, bracket where the order dated 17 July 2009 of this court has been set aside. And the order and OA number 86 of 2008 has been revived before the Commissioner of Endowments. We'll stop. This fact is perhaps not known to the present applicants / petitioners. Stop. It is now evident that OA number 86 of 2008 is indeed pending before the Commissioner of Endowments, as is OA number 3 of 2013. Stop. The only modification, therefore, of the order dated 11 January 2023 would be that both the aforementioned OAs, that is OA 86 of 2008 and OA 3 of 2013, will now be disposed of by the Commissioner of Endowments in accordance with law. Full stop. The remaining part of the said order does not require any further modification. The
Yeah, to
application-
scope part, your lordship may.
It is there in 86.
In 86
That may be recorded, your lordship.
It is
I
there.
am not aware of.
Okay. Council opposite party number 5 further points out that in OA 86 of 2008, there's already a status quo order passed by the Commissioner, which is continuing. All right.
Item number 10.
Defect not removed, sir.
May please, Your Honor. In fact, the order has been filed. It's a certified copy and the date is also there, but I don't understand why they are saying no date has been mentioned. I'm not able to understand the mistake.
What's the question of law here?
In fact, the addition is under section 68, cash credit. The appellant, in fact, is a company duly incorporated in the month of May 2006. And for the period May 2006 till 31st March 2007, that is assessment 7-8, a return was filed disclosing nil income because the company didn't start its commercial production. But on an unsecured loan of 45 lakh some odd was disclosed in the audited account. That was verified by the AO. Assessment was completed under section 143(3). The AO issued notice. All the detailed address of all 244 farmers along with their voter identity card and confirmation was given. But it was disputed by the AO without any further inquiry. The AO disallowed and added under section 68 of the Act. Before the CIT appeal, all the confirmation, all the details were provided. The CIT also writes in the order that confirmation was given by all of them. It was identified. But he said, he applied Sumiti Dayal case in the Supreme Court, preponderance some probabilities that it may not be possible. All 244 farmers have given money in cash towards unsecured loan amounting to 7,500 to up to 19,500. To challenge the rigor of 48(3), that is cash payment beyond 20,000. Between 20,000 they have given. This is the seed money utilized, which subsequently returned back to them. In audited report, that money has been returned in 2013-14, and it is accepted by the department. Still, this addition is confirmed. Secondly, the company was not in operation during that period, so that money cannot belongs to that company in any way. So, no addition under section 68. This is what has been challenged.
There are concurrent findings, no, sir?
You know?
CIT-A, IT-80, all of them concurrent.
No. IT-80, in fact, is the first, it is set aside to the AO for re-verification whether the loan amount has been repaid or not. And then in the second ground, the assessee appeared, provided the documents, but still he made these additions. And it went to the IT-80. IT-80 directed particularly the AO to call for records and issue summon under section 131 of the Income Tax Act, or use the power under section 133 subsection 6
Oh, you
of
didn't
the
appear
Act.
before the IT-80?
Your Honor, may I minor?
No, the impugned order.
Yes.
You did not appear.
They appeared before the IT-80.
No, come to page.
Your Lordship, page 43.
First order, it was dismissed for non-prosecution.
Oh, then
Second, in MA, it was restored.
Yes, yes. Okay. No, it's come to para 7, sir.
Of which order?
Page
Page?
43.
Yes.
At the time of hearing, when asked by the bench why the direction of the tribunal was not complied by the assessee, Lord, here the assessee did not give any satisfactory reply. In fact, the direction what was given was a
Why don't you
direction.
just complete reading it?
Yes, ma'am. Here the assessee did not give any satisfactory reply. We find that in the first round of proceeding, the tribunal was directed the assessee to produce all the creditors before the assessing officer to confirm with the evidence that the amount has been repaid. In fact, this finding is wrong.
No, 1 minute, sir. Just read on, then we.
But the assessee has failed to produce all the creditor before the assessee officer. Therefore, the addition was again confirmed and was upheld by the said appeal. In view of the above facts, we see no reason to interfere.
Where is that earlier order of the ITAT?
Said.
Right here. The ITAT is earlier order.
Earlier order is quoted as page 43 of the same order.
Right.
Therefore, in the interest of justice and fair play, we reverse the finding of the CIFL and restore the matter to the file of the AO to verify the genuineness of the transaction. The AO is directed to verify whether the assessee has repaid this amount to all the persons stated in the account in the various years by calling all the creditors. Therefore, the AO is directed to verify, and the assessee has already repaid the amount, it may be deleted. So, but the ITT second ground writes, the assessee was that.
What is the AO? Show us the AO's order now.
Now, AO says, AO asks for the details to the assessee. And in fact, 10 years has, more than 10 years has passed, loans has repaid.
Read out, sir, read out. Annexure 4.
Page 29, para 3.5.
All right.
In spite of the communicating the direction of the Honorable Tribunal by notice issued under section 142(1) dated so and so, and specifically requiring the assessee to do so during the course of hearing, hold on so and so, and for which the assessee had sought for time till 19/2/2016, had not complied with the production of the loan creditors to verify the genuineness of repayment of the loan as directed by the Honorable Tribunal contained in its order dated so and for which purpose the assessment made under section 143(3) dated so and so had been set aside. Though sufficient time of opportunity had been provided to the assessee has not availed the same to produce the creditors for verification.
What did you produce? What did you produce?
The reason being, the assessment year is 7-8. Now they are farmers of Balesur. They also give the confirmation before the AO and the CIT in the first instance. In the second instance, in 2016, the proceeding took place at Bhubaneswar, that more than 200 kilometers from Baleswar. And then all these notices, assessee asked those people to appear. But assessee also requested the AO to use his power under section 131 to issue summons or under section 133 within bracket 6 for information for those people. They are farmers, they don't have PAN numbers, they don't file returns. They are apprehensive of this proceeding. So they didn't come. In the first instance, 10 people came.
So once you took the remand order from the ITAT, you did not challenge it, you have to comply with it.
This is the remand.
If you thought it was impractical to get 200 farmers, you could have asked the ITAT by filing some application saying modify it, permit me to file affidavits of the farmers.
This remand report of the AO, where they have appeared and confirmed, and the CIT himself writes in the order, all of them giving the confirmation.
Where is that? Where is that?
That is CIT appeal order. Just a minute, madam. Madam, page number 20.
No, page 34. Page 34, para 2.1.
The course of appeal to hearing, the land here, the assessee has submitted that the loans in questions have been repaid subsequently during the year 13-14. In this connection, he had filed a copy of the audited accounts for the assessment 13-14. It is the contention of the air that since loans have been repaid, them should be treated as genuine. And please, kindly, my lord, page 20.
No, you're jumping, sir. Just go on next para.
This is the second proceeding before the appellate authority.
No, come to para 2.2.
I have considered the matter with reference to the facts of the record. The direction of the underwriter to the AO was to verify whether the assessee has repaid the loan amount to the alias creditor by calling the creditors. The AO required the assessee in the course of press assessment proceeding to produce the creditors. Just before calling the creditor, then the AO required the assessee to produce the creditors.
So what, sir? Either way, the point is you are saying did you produce affidavits of those farmers?
Yes, we did. That is the remand report we have given in the first instance. All the affidavit and confirmation are given. I have
not in the first instance, sir. At this instance, when we went back on remand,
in the second instance, all the confirmation was given. Everything was given, but they were not produced. Personally, they could not be produced.
No. What else? No, we're not talking of personal production. Did you file affidavits of the farmers?
Yes, confirmation was given.
After the remand?
Second remand, no confirmation given.
No problem, sir. Now, let's look at what you did after the remand by the ITAT. After the remand by the ITAT, even if you did not produce the farmers, did you produce their affidavits after the remand?
Yes.
Not in the first instance. After the remand, did you produce affidavits?
Produce the same affidavit which was produced before.
It's not enough, sir.
And my lord, there is another thing. I am citing 3 judgments. Even if assuming that they didn't produce confirmation, that didn't produce anything, still addition under 69, 63, 68 cannot be made. Because this money doesn't belong to the company, it can go back to. Now, para 2 of the judgment, I would like to read. The assessee company is an engineering construction company. It commenced business in May 1943. In their account book, there was several cash credit entries in the first year of its business. We are concerned with only 5 of those cash credit entries. On June so-and-so, there was a cash credit entry of so-and-so. On July so-and-so, there was a cash credit entry of so. August so-and-so, cash credit entry of so-and-so. There is a cash credit entry of rupees 15,000 on March 1594. There is a cash credit entry with it. This cash credit entry is total up to 2,50,000 rupees. The income tax officer called upon the assessor to explain those cash credit entries. The explanation given the assessee was found to be false by the income tax officer. The appellate assistant commissioner and the tribunal, but all the same, the tribunal felt that the cash credit entries could not represent the income of the profit of the assessee company, as they were all made very soon after the company commenced its activities. In our opinion, though the order of the tribunal is not happily worded, its finding appears to be that in the very nature of things, the assessee could not have earned such a huge amount as profit very soon after its commenced its activities. A construction company takes time to earn profit. It could not have earned a profit of rupees so and so within a few days after the commencement of its business. Hence, it is reasonable to assume that these cash credit entries are a capital receipt, though for one reason or other, the assessor had not come out with the true story or regard the person from whom it got those amounts. It is true that in the absence of strategic explanation from the assessor, the income tax officer may assume that cash credit entries in this books represent income from the unused sources. But that inference should be drawn from the facts above in a question of fact, and the tribunal finding of the fact question is final. In this case, my point is, even though if you say, assuming that this money is undisclosed income, it cannot belong to the company, is a separate legal entity. If you have to add, it might be somebody's undisclosed income has to be. If you don't believe, it has not been given from the farmers. In fact, Baleswar is the rice bowl.
So you are given one more chance to prove your case. You fritter away that chance, then you come back and say, no, I had already produced. That's not good enough.
My lord, but direction was for the AO to call for the persons.
You could have produced at least affidavits. You did not do that, sir.
affidavit once produced, the same affidavit was produced again. And it's a matter of passage of more than 10 years, my lord.
That's
My lord, another two judgment on the same issue that initial year, this money doesn't belong to the company. After all, you can leave the corporate veil, you can catch hold of the directors and managing directors if you want. But this addition cannot be done under section 68 in the hands of the company. It's a separate legal entity.
all right. This appeal by the SSC is directed against a judgment dated 22nd, order dated 22nd January. No, sorry, order dated
May I pray, my lord?
8 July 2019.
My lord, at least for sake of, because the assessee is fighting 3 times with the tribunal, twice with the state appeal, and twice with the assessing officer. Let it go back. Let me.
No. Enough.
If
Everything has to
My
come to
lord,
an end someday. Against an order dated 8 July 2019, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, IT-80, dismissing the SSC's ITA number 328/CTK/2017 for the assessment year bracket AY 2007-8. Is it 11-12 or 7-8?
7-8.
All right, because wrongly typed. 7-8. All right. Correct. The short question is whether the assessing officer bracket AO was justified in directing an addition of rupees 45,29,020 to the taxable income of the appellant under the head single quotes unsecured loan unquote under section 68 of the Income Tax Act 1961 bracket Act. Paragraph. Before the IT-80, it was the second round of litigation. Full stop. In the first round, the IT-80 had remanded the matter to the AO with certain specific directions as under reproduced on page 43 top paragraph. When the matter went back before the AO, the SSC did not produce the 200 odd farmers from whom the SSC had borrowed an unsecured loan of amounts ranging from rupees 9,500
7,500 to 19,500
to rupees 19,500. Full stop. The AO observed that the SSC had failed to produce those farmers to make good who would have confirmed before the AO that the statement of the SSC that they had been repaid the loan during financial year 2013-14 was in fact correct. Paragraph. It was sought to be contended by full stop. The above observation of the AO has been concurred with by the Commissioner of Income Tax bracket appeals bracket CIT bracket A in the order dated 19th May 2017, where it is observed as under in paras 2.1 and 2.2 paragraph that you reproduce 2.1, 2.2, page 34. Mr. Monty, learned counsel appearing for the appellant, sought to contend that in terms of the directions issued by the ITE, it is the AO who should have issued summons to the farmers in question to verify the facts. Full stop. The directions issued by the ITAT in the first round was to the effect that the AO should verify. No, that the AO should verify whether the assessee had repaid the amount. Open quotation, by calling all the creditors, unquote. Therefore, it is the AO who should have issued summons to them to appear. Full stop. Even assuming that the AO did not do so, the fact remains that the assessee did not ask for summons to be issued, and the assessee did not produce any fresh affidavits of the lender farmers to confirm that their loans to the assessee had been repaid to them. Full stop. The assessee could have easily done this to satisfy the requirement of the directions of the ITAT in remand. Paragraph. Counsel for the appellant then cited the decision of the Supreme Court of India in Commission of Income Tax versus Bharat Engineering and Construction Company, 1972-83, ITR 187, bracket SC. Full stop. There, the Supreme Court declined to interfere with the finding of the ITAT that the assessee could not have possibly borrowed the huge amount sought to be added as cash credit, unexplained cash credit. And the Supreme Court deferred to the finding of the ITAT on facts. Full stop. In the present case, factually the ITAT has found the addition to be justified. And going by the ratio of the aforementioned decision, this court should not interfere with such factual determination by the ITAT. Full stop.
My lord, other judgments? Close. My lord, may I-
Mr. Mohanty then cited India Rice Mills versus Commission of Income Tax, 1996, 218 ITR 508, bracket Allahabad, stating which held that the individual partners of a firm had to explain the sources of the deposits, and the addition could not be made in the hands of the firm under Section 68 of the Act. Full stop. Again, on facts, this decision appears to be distinguishable, since in the present case, it is plain that the appellant did not comply with the terms of the remand order of the ITAT in the first round. Paragraph. Lastly, Mr. Mohanty cited the decision dated 12 January 2009 of the Rajasthan High Court in ITA 185 of 08, bracket Commissioner of Income Tax, Bikaner versus Messrs. Cable Krishnan, bracket. On a perusal of the said order, it again appears that it is distinguishable on facts. It was held that it was for the partners of a firm to explain the sources of the deposits. And if they fail to discharge that owners, the addition could be made in the hands of the partners and not of the firm. Full stop. In the present case, the facts are entirely different, and therefore the said decision does not help the appellate. Paragraph. The court is unable to find any substantial question of law arising from the impugned order of the ITAT. The appeal is accordingly dismissed.
My lord, may I have one line? My lord, page 20, just one paragraph. Whatever decision my lord take will take, one paragraph. Page 20.
All right.
This is the appellate order, where inside the appellate order, the appellate authority writes, during the appeal and remand proceeding, admittedly the appellant filed the proof of identity confirmation in respect of 244 farmers. Some of the alleged creditors also appeared before the AO and stated before him that they had given the alleged loan. But as correctly stated by the AO in his assessment order, mere furnishing of proof of identity and confirmation is not enough for discharging the owners.
This is the first round, sir.
Yes, sir.
Not the second round. All right.
Item number 11.
Wait.
The petitioner is challenging the order of the state government dated 22nd December 2020, whereby the letter of intent issued in favor of the petitioner was revoked, and the upfront payment and the bank guarantee was forfeited. Now, my lords had passed an interim order. There was no stay. Meantime, OMC has got the lease and they have been working the mines. Now, the problem is today, even if I get the main relief, I'm not going to have the same mine for which I have bid. I will demonstrate that the order is incorrect. If that is so, I am restricting my prayer only to return of the money that have been forfeited with interest. They're getting the lease today is really not going to be beneficial to me. Therefore, if your lordship will kindly have a look, I have filed an application for that purpose. Please see the entirety of the reasoning of the order. The impugned order, operative part is at page 125. It starts at page 112, 22nd December 2020.
Yes.
The operative part says, now therefore, after careful consideration, government have been pleased to revoke the letter of intent issued by the letter dated 2nd March in favor of Shamors for grant of mining lease for Jilling Langlota block for Aino in villages also, and further order the forfeiture of all 3 installments of upfront payment totaling rupees 90 crore 60 lakh 13,852, and also the bank guarantee towards performance security amounting to rupees 90 crore 60 lakh 13,853, above penalties without prejudice to any other penalty. Now, I have a list of dates to show what is the allegation, and then kindly have a look at that. I'll quickly take my lords through the list of dates. Will be given a copy to the. 6th December, State Government of Orissa issued a notice inviting tender for grant of mining lease in respect of Jillings also. Ex-lessee SL Mining filed a writ petition before the Supreme Court seeking restoration and prayed for stay of auction process. On 5th February, e-auction in respect of subject mineral block was collected. Petitioner was placed highest, that is 135% of the final price offer. On 14th February, Supreme Court directed that auction will be subject to final order of the court. 15th February, petitioner was declared as preferred bidder pursuant to the auction of 5th February in terms of mineral auction and provision of tender document. State government directed the petitioner to make payment of first installment, upfront payment. Petitioner made payment of first installment of upfront payment within 4 days, 19th February. 2nd March, state government issued a letter of intent in favor of petitioner. Petitioner conveyed it in principal acceptance on 16th March. 20th March, sub-rule 6A, because the rules which they are invoking is made post the auction, 20th March, which prescribed a 15-day period. Earlier, it was 3 plus 2, 5 years. Whatever that is, even assuming these rules apply, I have complied with this, my case, but in any case, they can't apply. It's subsequent to the auction. Now, 31st March, petitioner conveyed its unconditional acceptance of letter of intent. 23rd April, state government accepted and approved delayed acceptance of letter of intent by the petitioner. 30th May, state government issued vesting order under Rule 9A of mining rules, thereby vesting all clearance approvals held by previous lessee in the petitioner. Period prescribed under sub-rule 6A, 6B commenced from here. There is no dispute on this. 10th June, in view of prevailing COVID-19 pandemic, petitioner made application before state government seeking extension of 15 days. This was granted on 12th June. 15 June, petitioner made payment of second installment.
11. Okay. Can we take it at the end of the board? Otherwise, the whole court will be waiting. Just take it at the end of the board.
Supplementary list item 12.
Item 12 may pray for next week, my lord, sir. Collected the brief from my learned senior, my lord, last night.
All right, at the request of Mr. Clerk. 17th August. Defects be cured.
Item number 13.
In item 13, my lord, your lordship has already issued notice. Postal request not depaid, I will depate the postal request by within 2 days. And similar matters have been fixed to 27/3/2023. That is writ appeal number 283 of 2022.
All right. List along with writ appeal 283 of 2022 on
27th March 2023.
27th March 2023. Fresh notice returnable by that date. Yes.
Item number 14.
May I please, your lordship? Well, the appellant has challenged the order and judgment dated 23/8/2022 passed by the learned single judge, wherein, my lord, the respondent number 4, who was the petitioner in that case, my lord, his case has been allowed and direction has been issued to reinstate him in his former post, although the very appointment of the respondent number 4 was ab initio void, my lord. My lord, 3 matters were taken together, my lord. Well, in a similar matter, in similar writ appeal, my lord, order has been passed and notice has been issued, my lord.
Where is that?
Given, my lord. Well, arising out of the same judgment, my lord.
All right.
And only difference, my lord, in this petition, my lord, the content has been filed. So, my lord, I pray for stay.
Delays condoned. Notice returnable 25th April 2023. List along with writ appeal 1360 of 2022. Stop till the next date. The impugn order shall remain stayed.
Deeply obliged, my lord.
Item number 15.
My lord, same order may passed. Odisha Computer Academy.
Same order. Right.
Item number 16.
May I please, your lordship? Lordships, the appellant in the present case, your lordship, is a charitable trust, lords. And main object of the trust, your lordship, is to educate the individuals and support service to the disabled person and children. And that's the reason of initiation of the assets 263 proceeding, lords, is that the appellant trust has received corpus donation during the year. And your lordship, that the PCI is stating that these corpus donation will be treated as anonymous donation and liable to be taxed under section 115 BBC of the Act, lords. Lordships, during the assessment proceeding and lordship before the CIT exemption, lords, and the assessee duly complied all the requirements as asked for, lords. Lordship, order under section 263 passed by the learned CIT exemption, your lordship, without making any inquiry himself, my lords. In this context, my lords, I am relying upon my lord's order, Honorable Delhi High Courts, in the case of Delhi Airport.
And will issue notice. It's a notice returnable.
Doesn't go with the
25th April.
Right. Extra copy kindly.
Right.
Item number 17.
That 17, 18 and 19 were same. But your lordship has already issued notice.
Correct.
Yesterday, item number 27, 28 and 29. Yesterday list.
What date?
Yes.
11/9. All right. Notice returnable 11/9. List along with. Right.
Ajay.
Item number 20.
My lord. My lord, in this case, in pursuance to search and seizure operation carried in the case of the assessees group, notice under section 153C has been issued, and thereafter assessment order under section 143(3) has been passed by the assessing officer on 31/12/2009. Accepting the return income with the addition under section 40.
Notice, Mr. Chiman, Mr. Satpathy accepts notice. 12th September.
Item 21.
21 was the 15 days delay, your lordship. And here, my lord, the
All right, just say notice returnable 12 September, delay control.
Yes, Your Lordship.
Item 22,
My lord, 22,
Exemptions again.
yes.
Let's see the order, impugned order.
Question is framed at page 6, my lord. Whether in the facts and circumstances of the case and justified in law is the order of the honorable ITT not perverse in allowing the SSC's foundation appeal only in the rule of consistency and without going into the merit of the case. Second, whether in the facts and justified in law is the order of ITT is not perverse in passing the order passed under section 263 of the Act, giving relief to the SSC foundation when the SSC has not established the reasonableness and market rate even before the honorable ITT. Third question is that whether in the fact and circumstances case and in law, honorable ITT.
All right, notice returnable 12 September. All right.
item 23,
My lord, at page,
How much delay?
19.
And the earlier one?
delay, not
It's condoned board. Why are you going after the state SC?
they say it is a state.
But
ITT is, but it's not a state.
anyway,
It is a company.
All right, notice returnable 13 September.
item number 24,
24, my lord, there is penny stock. So Your Lordship say the question is whether the exemption order 1030 will be applicable in this case or not. Your Lordship say the statement of the broker is clearly stated that it is a penny stock. Your Lordship see the I'm placing my lord running page 32, internal page 70 of the traveler's order. And this is as evidence basing on which my lord the department is disallowed the claim. May I place my lord the statement of page 32.
All right, notice returnable 13 September. All right.
Second also same, my lord. Same.
All right,
Arrangement the same.
25 also. Same.
item 26,
26 not
Steps for limitation not taken yet.
no, there is no limitation. Not one blood 190 120 days a period. I have filed in within 119.
All right, it stated that account of the orders concerning the COVID-19 pandemic, there's no delay.
Here the question blood is page 9. Deleting the addition made under some 13,72 on the account of NBP net versus net profit value. Earlier also, I think we should accept notice on this issue.
All right, you say notice, he accepts notice for OMC.
Yes, on behalf of the.
14 September.
Yes. Milord, another 2 minutes I have not prepared this. I need further.
27, 28, that is
Which
limitation
one?
is also.
28 and 29.
No limitation there. There is no
27 and 28.
say 190 days I have filed within the limitation.
That 27, 28 are different matters. Is it?
I need some time. Milord. I have to take further instruction from the department.
All right, in
After
27 and
market-
28, you said the request of Mr. Satpathy who needs time for instructions. List on 18th April.
18.
item 29,
Yes, no. The question has been framed at page 6, my lord. Whether in the fact and circumstances case, the honorable IT is justified in law in passing the notice under section 263 and revisionary order under section 263 of the IT Act passed by the CIT exemption, holding the revisionary order of CIT exemption 263 dated 31st March 2001 is not sustainable, being bad in law and passed in violation of principle of natural justice, where the CIT exemption has categorically found that the order under section 143 passed by AO is erroneous and prejudicial interest of revenue. Second, whether in the facts and circumstances of the case and in law in order.
So it's basically 263.
Yes, my lord.
What do you
Lordship,
I am relying on my lord's order, Orissa State Police Officer. But Lordship, this is clearly based on the facts, my lords. Honorable ITT has gone through the facts clearly, my lords. And Lordship, issue is that Lordship cost of I'm consistently playing. My lords, fundamental accounting principles, my lords, going concern consistency act. My lords, rules of consistency have been followed since last years, since past years, my lords. Lordship, issue is that CIT observation is that the AO accepted the return of income without making addition of depreciation into total income as the cost of the assets are already allowed as application of income. Lordship, totally, I have never taken the cost of the assets towards application of income. Your Lordship, this is my lord's order. He has covered my lord's learned ITT covered my lord's orders, Lordships, and entire fact has been. Lordship, this is a case on ITT has passed rightly, my lords.
At page 43, my lord. Claim of depreciation as application of fund, which is wrong.
Lordship, the assessee has never, my lords, the assessee has never taken the cost of the fixed asset as application of income, neither in the previous year nor in the past years. This has duly been considered, my lords, by the learned ITT, my lords. Lordship, Lordship will have a glance to Lordship ITT order, my lords, paragraph number 29, my lords, page 17, my lords.
Yes.
Last part. Therefore, in view of the above, no discussion in the assessment order can be a basis for alleging no inquiry, and the exercise undertaken by the AO cannot be ignored and brushed aside. The learned CIT DR, relying to the omission of the learned AO, also submitted that the res judicata doesn't apply to the proceedings, but at the same time, we are also agree with the learned AR that it is also a well accepted proposition that the rule of consistency has to be respected in the tax proceeding by the tax officers as per the judgment of the Honorable Supreme Court in case of Radhaswamy Satsanga versus CIT, so and so. In the present case, the assessee was claiming depreciation since several previous assessment years, and he submitted audited financial statement for the financial year 2012-13 to 2015-16, including present assessment year 2016-17, my lords, has successfully demonstrated that it has not claimed the cost of the asset as application of income at the time of purchase or acquisition of the asset, but only claim depreciation as application of income, availing the second option to claim the depreciation, and this was consistently claimed by the assessee and allowed by the department. Thus, the AO was not required to go into the micro detailings of claiming depreciation by the assets. Well, Lordship will see that page 19, my lords, also that my lords, last part. In the present case, the AO has notice issued under section 141 of the Act, along with questionnaire, asking the assessee details the basis of claim as application of income of the assessee, which was replied by the assessee, and the assessment records public holders for immediate.
So the appeal is dismissed, we'll pass the detailed orders.
No, the claim on the page 43.
Consistency rules, sir. We'll follow the rule of consistency. All right. Delay is condoned, appeal dismissed, we'll pass the detailed order. All right.
Thirty.
May I please, my lord, present petitioner is the rightful owner of a suit property, my lord. Over that, present petitioner have constructed a Pradhan Mantri Awas Yojana house, my lord. There are OP number 6 possibly occupied the said house without my consent, my lord. For that reason, I have
Not a PIL, sir.
How can it be a PIL?
How is it a PIL?
no, my lord. It is not PL, my lord.
And then it's not writ also. You have to file suit. This petition can neither be treated as a public interest litigation nor is the subject matter amenable to a writ jurisdiction. The remedy of the petitioners lies elsewhere, permitting the petitioners to avail other remedies as may be available to them in accordance with law. The petition is disposed of. Right.
Item 31.
Challenging the inaction of the authorities in complying the special audit report. The writ was filed before single bench. It has come to PL bench. So 4.5 years have passed, no action has been taken by the authorities.
No, but what is your locus? Simply resident of Jagat Singhpur, that's it.
Because he's an ex-director of the corporation. And Millers, he has named certain people in para 12, not parties here, against whom he says that they have siphoned money and all sorts of allegations.
What is the date of the audit report?
Date is
2018.
20th June 2018.
All right, just say notice. You accept notice on behalf of opposite parties?
It's one.
All of 1 to 4. Notice to opposite party number 5 by registered.
Well, is this 3, 1, 2, and 3? Because Administrator Orissa Cooperative Housing
All right,
Corporation.
notice to 4 and 5 by speed post returnable on July. Replies be filed within 4 weeks of service of notice of rejoinder. The next step. Correct.
Item number 32.
32 relates to for grant of on license. For last 2 years, the public are filing an objection and it was dropped. Again, this year on same self plot, they have invited public notice inviting objection by the collector. I have filed a detailed note objection stating about also lordship's direction was there to consider. They have considered and dropped. Again now, this year they have issued again public notice. There I have also enclosed this on court's order also. Annexure 5 is pending.
No, but you have filed your objection.
Yes, Annexure 5.
So
That is to be considered because it is pursuant to public notice. It is within time also.
What your lordship will find from the date chart, one PIL was filed earlier in which direction was given to.
That was last year.
No, it is 8320 to 2022. And the pursuant to that, one miscase was registered and notice was issued. And the date was fixed to 24/11/2022. And what happened thereafter?
The lordship kind of glanced the public notice, Annexure 3.
No, it is your date chart.
Yes.
Last
19.9 is the public notice, my lord.
No, what happened to that earlier writ petition?
No, earlier writ petition was disposed of. The lordship directed that to consider the objections filed by the public. But that they have not.
And
They have issued
got no
notice.
fresh
But
advertisement.
I have not been issued notice, though I have filed in time. I have filed in time. My objection of lordship clients dated is 110.
You want to take instructions?
I want to take, but your lordship will see page 39 for a while, your lordship. Page 39.
Yes.
That I am saying. That notice has been given to the
This is
party
a
which has
notice
filed writ petition,
given
but I have not been issued notice where I have filed objection in time.
Objections are already being dealt with by. That is what I want to appraise your
No,
lordship.
he says now there's a fresh advertisement.
Yes, press notice. Annexure
That
3.
the writ petitioner was heard. Again, another writ petition is filed. So by this process, your lordship may say that if his objection is within the time period
Yes,
fixed
within
to
time. That I am saying.
format notice, then the collector may.
No, last date is 3rd October. My application is 1 October.
All right. Concerned petitioner states that a fresh public notice for
Under Annexure 3, page number 9.
has been
Dated
noticed on
19th
September
19th September 2022.
Yeah, 19th September 2022, inviting objections
And my objection is 110/2022.
to grant an on-shop license. IMFL on-shop license in Moza Gopapur, District Jashpur. And that the petitioners have filed their objections in time on 1st October 2022.
Under Annexure 5.
Bracket Annexure 5. Full stop. That view of the matter, if indeed the objections have been filed within the time stipulated, a decision will be taken only after considering the such objections.
Another point your lordship may imagine, consider, if the matter is still pending before the collector. I don't know whether the collector has already recommended it to excise commissioner.
No, it is not.
No.
Twice it is dropped, my lord. Rather,
No, this
no
time.
grant was granted.
This time, whether this object,
We hold good.
This
The
time,
collector has not already
if
made
you say that it is
recommendations.
pending, your lordship can record the statement of the petitioner.
Yeah. The petition is disposed of about this. All right.
Provided it is pending at the level
That's
of
what I've
collection.
said. I've said that.
Item number 33.
May I please, your lordship, the public water drain is going to be vanished by the private opposite partner 5 to 7. This is the status of this is the plot. This is a drain, water drain annexure 1. This is the water drain, and the villagers are now using that is for the extract the water
Sir,
in the rainy season in that drain.
1 minute, sir. Come to annexure 4.
Yes, annexure 4, my lord. Annexure 4, the representation to the collector and Tahsildar.
Where is the proof of submission?
My lord, regarding the necessary steps.
So kindly listen to the question. Where is the proof of submitting this representation?
The proof means we have a your lordship see paper in the paper notification next day. Next month, your lordship page. That is, we have
Mr.
page annexure 3.
Mr. Raj,
yes.
my lord wants to know the acknowledgement.
But they did not.
Acknowledgement.
Yes, they did not give any acknowledgement.
You have to get one, sir.
Public notice,
No,
in
no,
the paper notification, annexure 3, your lordship see. This is a notice in the newspaper. It has come on the agitation of the public. It is the agitation in the annexure 3. And also, your lordship, annexure 5, there is the RTI information. Why that is a public. There is no work order issue. And the opposite part number 5 to 7 are putting there all the mods and sands and for the preparing a personal route for their my lord, for their convenience. But it is a water their status is going to be vanished.
Permitting the petitioners to file a fresh representation, and after following up on such a representation to seek appropriate remedies in accordance with law, the petition is disposed. All right.
Item number 34.
Your lordships. In item 34, in the last order, your lordships are directed to file a substitution petition, which I have filed it today, your lordship, as IA number 1993 of 23. And for the defects, your lordship may grant me today time, 1 day time. I will cure it by during the course of the day, your lordship.
It's all 2021. So you can't keep granting this kind of time was granted on 12/11/2021 to the petitioner to file a substitution application, and 4 weeks time is granted for the purpose. Full stop. After more than a year, only today an application for substitution has been filed. Defects have not been cured. The court does not propose to grant any further indulgence. The petition is dismissed. Yes.
Item number 35.
Malords, 35, Malords, we have received Paravez, Malords, may grant 10 days time, will file countermarks.
Counsel for the court seeks and is granted last opportunity of filing the reply within 8 weeks. Rejoined up for the next date. 23rd August.
Malords, so proceed.
Item number 36. May please.
Sorry, 24th
My
August.
lords,
24th August.
My lords, I was before the tribunal, my lords. Tribunal remanded the matter to the first appellate authority to see whether it is covered by my lord's judgment on case of automobiles, my lords. Because 30
case was not there.
39 was not. My lords, what happened, my lords? Instead of first appellate authority, the assessing authority simultaneously under 39 and 43 passed the order, my lords. My lords, kindly turn to page 18, my lords.
Yes.
Page 18, my lords. Tribunal's order. Para 9, my lords. May I place it?
Which is this? Your writ petition is 334.
My lords, next one, the lead ones, 37, your lords. May kindly take.
No, there is no page.
No, he's now talking of the next item now.
My lords, VAT and anti-tax 2 matters.
Yes, yes.
But both are same in our case. You have supplied same copies in both the cases.
I'll supply one. My lords, next one, 37. Page 18, my lords. Para 9, my lords. Lords got it.
So remanded to the first appellate.
My lords.
But it went to the assessment.
My lords, they have assessing.
Usually the assessment record is available with the assessing authority.
No, please. You have to follow the remand, sir.
How he will assume jurisdiction, my lord.
Both these matters, you see, this previous order dated. 3rd July 2019 of the Odisha Sales Tax Tribunal, Cuttack, that the remand was to the first appellate authority, not to the assessing officer, bracket AO. Instead, it is the AO who has considered the matter afresh and passed the impugned orders. Assessment orders dated 30th June 2022. On that short ground, both the impugned assessment orders are set aside, and the matters are directed now to be placed before the first appellate authority, which is the ACST.
My lords,
No, current designation must be what?
you can give
States something.
JCSTF will be.
Which you?
I will give, my lords, I will give.
No. Where? In Jajpur itself or in Cuttack?
Jajpur Road,
Before the first appellate authority, that is the dash, you say, he'll give the name, where it will now be listed on 10th April 2023, on which date the SSC will appear through an authorized representative along with the downloaded copy of this order. The petitions are disposed of in the above terms. A copy of this order be sent to the concerned authority by the registry forthwith. Right.
Item number 38.
My lord, I'm My lord, I'm appearing for the petitioner virtually.
Yes.
There is a defect. The copies have not been served to the opposite parties.
All right.
The copy is being served today.
List on.
Attachment order has been passed. That has been.
You say the attached. You have that order, which last time we passed in similar matters. All right. It is stated that the bank account, the petition has been attached for the purpose of paying the above 20% amount. The attachment will be lifted. And after payment of the amount, and after withdrawal of the amount for such payment, the attachment will continue. The copy of this order be sent to which bank? You have mentioned the name of the bank.
Bank, Central Bank of India. Khatrajpur, Sambalpur, in this case, I have stated. I have stated.
Copy of the order be sent to the branch manager. Central Bank of India, no coercive steps shall be taken against the petitioner during the pendency of the writ petition. The IA is disposed.
There is an observation that 10% you have not deposited. Now you have deposited.
No, that is deposited, my lord. Your lordship may see
the first application.
My lord, page 16, 87,226. The credit ledger is deposited because the accounts are raised for that reason.
Item 41.
41 and 42.
My lord, item number 41. My lord, it's in order because of an IA number 317 of 2023 for extension of time. My lord, matter was on board on dated 19 of 12, 2022, challenging the audit report demand. The lordship was pleased to dispose of the matter, directing to treat the impugned demand notice as a notice and to file reply before the government within a period of 2 weeks. Now, as because petitioner was not doing well in his health, he couldn't file the reply within 2 weeks.
For the reasons stated therein, the applications are allowed. The time for the petitioners to file a reply is extended up to 3rd April 2023. The reason order be passed now by the authority, that is the state government, not later than 1st May, and be communicated to the petitioner not later than 8th May.
My lord, rest part of the order be remain intact.
Yeah, the other part of the order will remain. 42 also same.
No, 42 is filed by the state for extension of the time period to comply your lordship's order and pass necessary order on the representation. That is till the end of March, your lordship.
All right. For the reasons stated, the application is allowed. The time for passing the order in terms of the order dated 14/11/2022 of this court is extended up to 3rd April 2023. The application is disposed of.
Item number 43.
My lord, I'm sorry, my lord. My lord, I was disconnected at item number 38.
Yes.
Item number 39 is the same matter, my lord.
Yes.
So item 43 to 50, my lords, those matters are identical matters and maybe hard along with item 75 of today's list, my lords. That is ready.
All right. Yes.
Item 51.
51, my lords. Mr. Rao has requested for an passover, my lords.
All right.
Item number 52.
So we can in 1 week time will be allowed for removal of the defect. Yes.
List on 29th March, defects be removed.
Item number 53.
Item number 53, my lord, the petitioner has already been expired, my lord, in the meantime.
All right.
If your lordship will kindly permit me to take steps for substitution, then.
No, it's okay. It's stated that the petition has expired, must have expired long ago.
During COVID, my lord.
All right. The petition is disposed of as having abated. All right.
May I pray one thing, your lordship? In this case, I am appealing for the opposite party. 133 2B application is pending, subject to acceptance by learned senior. If the
stay is interim orders vacated, that's it.
And the matter may be kindly remanded to the CGIT Labor Court for the industrial tribunal.
There, my lord, I will take steps for substitution, my lord.
All right.
Matter may kindly be remitted to the CGIT Labor Court.
Matter will now be listed before the CGIT Industrial Tribunal.
CGIT Labor Court,
Bhubaneswar.
And the Industrial Tribunal Ralpla may be directed to remit the matter
on 10th April. On you say 8th May 2023, the records will be transmitted to that court by the CGIT Rourkela. Copy of this order be sent to both CGITs. All right.
My lord, your lordship may, my lord, kindly indicate
Steps
that.
for substitution can be taken before the CGIT.
Yes,
All right.
ma'am.
All right.
Item number 54.
For the opposite party.
Your lordship, I am appearing for the petitioners. Mr. Pinaki Mishra, senior advocate, is appearing in this matter. I'm just seeking a short passover. If it kindly be passed over.
There's already another big matter.
I understand, your
Not be able
lordship.
to take it up and pass away. See, there are other.
Yeah, they have taken time for a very long time. I can kindly see the order.
I know, but today Mr. Vaidyanathan is waiting for his matter, and that seems to a longish matter. So, Mr. As passover is sought the passover is sought on behalf of the petitioners convening to the court. List for panel hearing on. We'll have it on the opening of the court. 27 June.
I am appearing for CCI, my lords.
All right, 27 June. All right.
27 June, your lordship.
Yes.
Obliged, your lordship.
55.
55, my lord, in pursuance of the last order, I filed the affidavit of Chief Secretary and lordship may take it off. That is hard copy today I have filed and it was filed.
Central Pollution, after the Central Pollution Control Board's report, my lord, lordship has directed the state to file an affidavit. Let a copy be served upon me, my lord.
All right. A copy of the affidavit dated 6th February 2023 of the Chief Secretary.
Of the Chief Secretary?
Yeah, be served on.
I'm appearing for the Central Pollution Control Board, my lord.
I am appearing for the Central Pollution Control Board.
State Pollution Control Board. I am appearing for the State Pollution.
And State Pollution Control Board. Stop. They may file their response there too before the next date. What about the petitioner? Oh, this is so moto, right?
This is so moto.
This is so moto.
List on. Let's see the PI list. April 4th April.
Item number 56.
May I please, my lord? My lord, kindly have a glance to running page number 17, my prayer. Issue a writ of nature of certiorari for quashing the notification number dated so and so, issued by the Home Department, Government of Odisha, in constituting a committee for consideration of various aspects for establishment of permanent bench of Odisha High Court in western and southern region of the state other than the principal seat, my lord. Now, my lord, while dealing with a matter, the Honorable Supreme Court pleased to observe, my lord, may I supply the copies?
Yes.
My lord, the relevant page is page number 4, my lord.
Yes.
I'm reading, my lord. Thirdly, it has been stated that demand for setting up benches of Orissa High Court is not only from Sambalpur, but also from Balangir, Koraput, Barampur, Balasore, Sonpur, Rourkela. This seems to have become prestige issue rather than a functional issue. In fact, Mr. Dattar says that only Koraput and Balangir fall within the parameters of Jaswant Singh Committee report of 1985, which prescribed at least a distance of 300 kilometers. Thus, in terms of that committee report, there is no question of setting up benches elsewhere. Now, my lord, I am taking your lordships to the page number 6, starts from fourthly. We are informed that from any district court in Odisha, one can file a case in High Court and also appear virtually. This has been possible with the technological progress. It is proposed that one dedicated room is in every district court premises in Odisha for the purpose of virtually appearing before the High Court every day will be functional soon. And there can be adjacent back office to such room which will facilitate e-filing of cases in the High Court. The time period of operational of the same is stated to be in 3 months. My humble submission, my lord, it has already been started. Hence, there is no need of committee to proceed, my lord.
No. If you want to withdraw the petition, you withdraw.
My lord,
you say that in view of this order, because the Supreme Court, you don't have any further grievance.
My lord, I don't have any grievance, but the committee is still there, my lord. That is my humble submission, my lord.
The committee will also read this orders.
Because that committee and specific direction has been given. What is the purpose of the committee? Why it has been constituted?
Yes, I'll have to take instructions on what is the view of the committee. I mean, what is the committee now, Millard's doing post this Supreme Court order.
You see, the petitioner who appears in person draws attention to the order passed by the Supreme Court of India on 14 December 2022 in miscellaneous application diary number the High Court of Orissa is concerned. A to A. Mr. Mohanty accordingly submits that the committee that has been set up by the state government by notification dated 28 August 2019 should not proceed in the matter. Paragraph, Mr. Mohanty, learned additional standing counsel for the government, states that he needs time for instructions. At his request, list on July.
Obliged, ma'am.
Item number 57.
Lordship, may kindly pass over 57 and 60.
All right. Will it take long?
No, Your Lordship, it's covered.
I see.
Item 58.
May I please, Your Lord? In this writ application, the question involved is squarely, one of the question is covered by Your Lordship's order in WCC number 18270. The question is whether entry tax is leviable on interstate sale. Your Lordship has now observed that it has to be decided by the Lordship remanded and has to be decided by the Deputy Commissioner. And they have also allowed the refund. Other two aspects, Lordship, other two aspects are the assessee had submitted F form, but inadvertently he submitted the duplicates instead of the original. So he refused to accept that and has now taxed it. We have the original. He can, if the remand is made, he can consider it.
All right.
And the third point is also that whether wax is a chemical, as also has been allowed by the first appellate authority in the subsequent years. So all can be decided, 3 issues.
All right. You see, the petitioner points out that 3 issues arise for consideration. One is regarding the refund application of the.
Not refund, my lord, only sale of whether entity tax is payable on interstate sale.
Okay. With what first is whether entity tax is payable on interstate. Sorry. Interstate transactions. All right. Full stop. The second is about wax. Where have we formulated that, sir?
Lordship,
the rectification petitions is 73.
page 73.
Whether wax could be treated as a chemical for the purposes of entry tax. And third, whether the petitioner should be permitted now to produce the original of the
F form.
F forms, which are available with it. As regards all 3 issues, it is prayed that the matter can be sent back to the assessing officer, is it?
Lordship.
That is the
Deputy Commissioner.
Deputy Commissioner of Sales Tax, Bhubaneswar 2 Circle.
Opposite part number 3.
Bracket opposite party number 3 for a fresh consideration. Full stop. Having heard learned counsel to parties, the court finds merit in the submission that all 3 issues required to be revisited in view of the orders passed by this court in similar matters, which shall be placed before the above DCST in accordance with law. The impugned assessment order is accordingly set aside, as well as a rectification order is accordingly set aside, and the matter will be placed before the DCST on 17th April 2023 for a fresh consideration of the above issues in accordance with law.
Gotcha.
The petition is dismissed.
The second matter is
a copy of the order be sent to the concerned DCST.
59.
The second matter is with regard to the OVAT for the same period, and the issue is whether LPG cylinder, ITC on LPG cylinders, and the same issue is now pending before this court. Your Lordship has fixed to 14th of August.
List on 14th August along with STREV 27 of 2016.
Not
all right.
Deeply.
Item number 61.
May I please be. Here the petitioner, my lord, is an small industrial unit, my lord, and it produces household plastic items, my lords. And pursuant to IPR 2007, which was with effect from 2/3/2007, it claimed certain entry tax benefits, my lord. If your lordship would kindly turn to page 12, I've quoted the exact.
Reply has been filed.
My lord, so-cause notice has been challenged. He has to produce
Your lordship would appreciate
certificate, my lord.
My humble contention, my lord, is as per the provisions of the IPR, my lord, and the finance department notification, my lord, there was no necessity, my lord, for an operational guideline. It did not stipulate, my lords. There, my lords, after, my lords, around 5 years, according to them, in 2013, an operational guideline was there published by the Director of Industries, my lord. That said, my lord, that a Form E has to be obtained in order to avail the entry tax benefits, my lord. And that should be within 2 years. Your lordship would appreciate, my lord, IPR 2007 came into effect on 2/3/2007. It did not stipulate an operational guideline or
production of a certificate by the issued by the DIC, my lords. Your lordship knows that as per section 6 of the Entry Tax Act, the finance department notification, if your lordship would kindly only see the finance department notification. Without this notification, I don't get a benefit so far as the OET part of it is concerned. Your lordship would kindly turn to page 58 now.
Sir, don't you want to file a reply?
My lord.
This notice was issued.
Question is whether
Yes.
operational guidelines fixing a time stipulation beyond what is stipulated.
In the IPR.
No, finance department notification. Can they have that power?
And the second question, my lord, this operational guideline came in 2013, 5 or 6 years, my lord, after the IPR, my lord. And it says, my lord, 2 years, within 2 years. So at best, my lord, can appear to be prospective, not retrospective, my lord, because my commercial establishment was there with effect from 6/9/2011, my lord. I started my commercial production.
Reply we filed within 8 weeks, rejoined up to the next date. Interim order to continue. List on 24th August.
Beg your pardon?
24th August.
Grateful one.
Item 62.
Item 62, my lord, on behalf of Mr. Patnaik, my lord senior, he is suffering from fever, my lord. So kindly advance.
The petitioner is stated to be unwell. List on 14th August. 16th August, sorry, 16th August.
Yes, ma'am. Interim order to be continued, my lord. Interim order to be continued.
Item number 63.
May I please? Similar order may be passed.
Yeah, all right. Understand the motion.
Item 64.
Well, it's item 64 and 65 infractors.
Infractors disposed.
Item number 66.
66, my lord, is covered by Keshav Auto, my lords. And if your lordship would appreciate, your lordship, those orders are there at the first page of your lordship's brief, my lord.
Correct. And Rathi Steels.
Sorry, my lords?
Rathi Steels also.
Rathi Steel also, my lords.
Correct.
Then the
And
last,
Pawan Jay, my lord, your lordships have said.
last occasion, we have instructed to produce the assessment order. If my lord will see in the first order of the assessment order, he has only as mentioned that self-assessment has been done. The order
But
number
there's
1.
no communication, lord. Your lordship has said that there has to be a communication. I have also obtained the certified
Original
copy.
record has been produced.
Fast
Which
order.
shows that the department has noted about the self-assessment return being filed by the petitioner, SSC, petitioner dealer. However, the record does not show that the acceptance of the self-assessment was accepted by the department and the acceptance was communicated to the dealer. In that view of the matter, applying the ratio of the decision of this case, of this court in Keshav Automobiles,
And Rathi
which has
Steel.
been affirmed by the Supreme Court of India and Rathi Steels. The impugned assessment order and the corresponding orders of the ACST. Is there an order of the ACST?
No, the Deputy Commissioner, my lords.
DCST are hereby set aside. The writ petition is disposed.
And in Pawan Jay, your lordships have also dealt with this communication part. May I just
Yes.
Pawan Jay. Pawan Jay. Paragraph 9, your lordship has
Notification will approved by Rathi Steel and the further order dated 28 November 2022. In writ petition civil 10349 of 2016 bracket Pawan Jay Sponge Iron Limited versus Deputy Commissioner. All right. All right.
Item number 67.
Obligement. Lordship just
67 to 69, TCS matter covered by my lords.
Item number 70.
None of this.
Item
Oh, one
7.
minute, one minute.
70, 71,
70.
72, 73, my lords, stands covered by a lordship's order dated 7/2/2023 of the same petitioner, my lords. I've just corrected those positions.
All right.
What is that? Relating to that
On shop.
on shop.
Yes.
Yeah.
No, the first two, my lord, the 70 and 72, my lords, are CS shops, my lord.
Right, right.
And the other two, my lord, is on shop, my lord.
On shops. All right. Same.
I've made the necessary correction.
All right.
The lordship quashed the demand notices in all the four.
That's it. That's
Much obliged.
okay.
I've mentioned the item numbers.
Yes, yes.
Item not 74. In the last occasion, your lordship passed an order directing the management municipality, the what steps has been taken, my lord, with regard to regularization of this petitioner and others.
Regarding period of service, your lordship asked regarding period of service. But after that award was passed, he had challenged this, my lord. That was challenged by the CMC and then ultimately in the appeal. So after 2011, again he has been allowed to continue and he has been continuing from 2011. And is just in a temporary post.
No, since 97, sir.
97, because law was amended. Section 73 says that without any sanction post, there cannot be any permanent appointment. That is why his appointment being made, that after that amendment, that is why he was discontinued.
When was he discontinued? Why didn't you file an affidavit? You said an affidavit be filed by the Cuttack Municipal Corporation explaining exactly the periods during which the appellant continued in service. The affidavit be filed within 2 weeks with a copy to counsel for the appellant. List on May. Sorry, 11th May.
11th
May.
Interim order.
Interim order to continue.
Okay. Item not 75.
May I please, your lordship. Very small question to decide it, Mr. Lorships. To challenge the order of the Honorable Single Judge. Here, my lords, the only sole question is, what would be the appointed day in pursuance to the amendment in 2017 of the Orissa Motor Vehicle Taxation Act? Here, my lords, I have given a date chart, my lords, with comparative chart of the statute. I had given a date chart, my lords. On 17/5/2018, the my lords,
yes, sir.
Here, my lords, this vehicle has been registered on 3/7/2012. The class of vehicle is the, my lords, Mexican. And by that time, it was paying the monthly tax, my lords, monthly mode. And the vehicle has paid the tax from 19/6/2012 to 31/1/2018, a monthly mode, till when the amendment came into force, my lords. This amendment came into force by Amendment Act 2017. So 21/11/2017, Section 4A, capital A, and subsection 1 has been substituted, my lords. I am placing to your lordships that annexure 3, my lords. That is the notification, page 14 to 21, my lords. That is page 14, paragraph 2. In Odisha Motor Vehicle Taxation Act 1970, so in section 4 capital A for subsection 1, including proviso, the following subsections shall be substituted, namely 1, my lords, page 15. Notwithstanding anything contained in section 3 and 4, but subject to other provision of this act, there shall be levied and paid in respect to every vehicle of the description specified in item 1 and 2 of the schedule 1, and every vehicle being motor car, including jeep, which is used personally or kept for personal use, covered under item 6 of the said schedule. Next, my lords, motor cab and maxi cab covered under item 4B of the said schedule, omnibus, private service vehicles covered under 5A, and educational institution buses covered under 5B of the schedule, which does not carry more than 12 persons, excluding driver, one-time tax at the rate specified in schedule 3. Provided that in the case of a motor vehicle, which Roman 1, my lords, is already on a road in the state of Odisha prior to the commencement of the Odisha Motor Vehicle Taxation Amendment Act 2017, herein after referred to as the appointed day. So my response submission is, so far this amendment is concerned, my lords, the effective date would be as per the Amendment Act 2017, that is 11, that is 17/11/2017 would be. But Honorable Single has held, no, when the Act came to 4, section 4A was not there, my lords. When this Odisha Motor Vehicle Taxation Act came into force in 1975, my lords. By that time, there was no one-time tax procedure. In my lords, 1981-9, for the first time, 4A has been introduced, section 4A, where the one-time tax have been introduced for the some vehicles like my lords, motorcycle and private vehicles. Thereafter, the law has been amended to time. In 2017, the petitioners of vehicle, the class of vehicle that is maxi cab and car, all these things, that had been introduced into the one-time tax. But prior to that 2017, November 2017, those vehicles purchased in 2012 or 13, whatever may be, those vehicle owners, they are paying monthly tax. So for first time, after the introduction of this, the Amendment Act came into force in 2017-11, those vehicles are brought into the one-time tax world. And section 4A, I had given a comparative chart, my lords. That is second page, your lordship. The date chart, along with the date chart, I had given a comparative chart, my lords. The comparative chart of section 4A was omitted in 1975. Here, my lords, 4A, it consists of 4 subsections, my lords. Well, lordship, that chart page 2, your lordship may see the page 2. After substitution of subsection 1 of section 4A, sorry, sir, page 3, your lordship may see. After substitution of subsection 1 of section 4A with effect from 21/11/2017, there are 4A, this is the substituted subsection 1. Your lordship may see the subsection 3, my lords. The levy and payment of one-time tax shall be compulsory in respect of vehicles registered on or after the appointed date, and optional in respect of the vehicles registered prior to that date. So my response submission is, my lords, in subsection 1 proviso, it is already there that is, in the case of motor vehicle, is already on the road in the state of Odisha prior to commencement of Odisha Motor Vehicle Taxation Amendment 2017. Here it reports the appointed day. So the amendment when came into force in 2017, the effective date, the appointed date is 21/11/2017. So if it will be read with the subsection 3 in consonance, then there is those vehicles purchased prior to 2017, it is for them optional. they may pay the tax either monthly mode what they were paying, or my lords, they may pay the one-time tax. That is the submission of my, that is the law, my lords. But honorable single judge held that in page, your lordship, page 37, my lords. The operative judgment of this, the honorable single judge, page 37, internal page 15. The petitioners tried to impress upon the court that since the Mexicab was under the fold of amendment of Act 2017 for this first time, and as such section 4A will be applicable under these categories of vehicle with effect from 21/11/2017, but this contention is not acceptable to this court. The reason being that even though under the old section 4A, which has been brought into effect with effect on 1/6/89, one-time tax was payable to every motor vehicle, not it's every motor vehicle, that is, my lords. Vehicle, some category, not every motor vehicle. As dealt therein above, the motor vehicles means any mechanical propelled vehicle adapted or for the open roads which are used only in a factory or in any other enclosed premises, or a vehicle having less than 4 wheels, fitted with the engine capacity not exceeding 30 PS. But the category of vehicle under item 4B, which includes Mexicab, is related to vehicle other than stage carriage vehicle, which includes or sitting not more than 6 persons for every person the vehicle is permitted to carry, excluding the driver so and so, more than.
Yes, who's for the
According to my considered view,
One
the
minute, 1 minute,
legislature.
Lordship kindly gone through running page 36, my lord. 33, my lord. The judgment of honorable single judge. But the may I read, my lord, that the sole question to be decided that which would be the appointed date, whether from the date of enactment of section 4A with effect from 1/6/89 or from the date of amendment stroke addition in section 4A by virtue of different notifications is issued in this regard. But keeping in view the judgment of Honorable Apex Court in Allied Motors Private Limited and judge, and the Commissioner of Income Tax and versus Podar Cement Limited, this Honorable Single Judge has held that the amendment is mean from the date of insertion.
Sir, these are all taxing statutes, sir. This is motor vehicle tax. Unless the tax is made expressly retrospectively available, it can't be made, sir.
Lordship kindly see annex.
Taxing statutes, you can't have retrospectivity. How can you have? Unless the statute itself says it is retrospective. Have you seen the amendments to?
It is.
You must have seen numerous amendments.
Whether
it's income tax, sales tax, you will see WREF. Have you seen that? Why have they put that?
Lordship kindly say that amendment. Very itself, it is retrospective.
No, sir. In fact, you have to read it in subsection 3. That what he read. That specifically they've inserted the subsection 3 for vehicles already on the road. It's optional.
Yes. No, Lordship kindly see that.
All right, read it.
Lordship first, Lord Annex of 3. Lord Annex of 3 provision. Lord page 15. Subsection 1.
Right.
Lord, that is the amended provision inserted.
Correct.
And the provisos provides. Lord provided that in case of a motor vehicle which is already on the road in the state of Odisha, prior to commencement of the Odisha Motor Vehicle Taxation Amendment Act.
Right.
Lord, prior to.
Correct.
Lord, there is a separate calculation for these vehicles for payment of.
Correct.
Lord, by interpreting this provision, my Lord, Honorable Single Judge has
You
held
don't
that.
want to read this full provision, it's up to you. We are going to read it. Whenever we write the judgment, we will read it fully. You want to stop reading it like this, it's your choice.
My Lord.
You don't want to read it fully.
My Lord, already on the road. My Lord, I will submit that provision, my Lord. the proviso of that
See, you
amended.
stop reading, no, we didn't stop you, we want you to read. You stopped it yourself.
My lord. Oblige. It is already on board in the state of Odisha prior to the commencement of Orissa Motor Vehicle Taxation, my lord, Amendment Act 2017. 2 has been purchased or acquired outside Odisha, but brought to Odisha on or after the
All this is not
appointed date.
applicable. 2 and 3 are not applicable.
Lord,
For his argument, 2 and 3 are not relevant, sir.
Lord, this is the intention of the legislature. Lord, his only point is subsection 3. Lord, subsection 3. Lord.
Sir, we've also been lawyers at the bar.
Well,
We don't start reading one provision and abandon that provision. 2 lines you're reading, you're abandoning. Then we're asking you to go on reading. You are refusing to read.
Lord,
You start arguing. Anyway, it's up to you. This is all your own style of argument. No, it's up to you, sir.
Subsection 3 has been quoted. Well, Lord, should kindly see the judgment. My lord. At page, Lord, at page 5, my lord. Page 5.
Yes.
Lord,
Yes.
Page 26 of the running page 26.
Yes.
Lord, 4A Lord, has been inserted by virtue of Odisha Act of 1989 with effect from 1/6/1989, which contains provisions of levy and payment of one-time tax. The said provision is being quoted herein below. Lord, it is not necessary to read that provision. Well, Lordship, next page, subsection 3 of that provision. The levy and payment of one-time tax shall be compulsory in respect of vehicles registered on or after appointed date and optional in respect of vehicles registered prior to that date. Lord, here, Lord, subsection 3, as per the Lord, submission of the petitioner, that subsection 3 has not been amended. So that provision is there. So this appointed date must be Lord, in the year 2017, as per the argument. Lord, Honorable Single Judge has held that the appointed, it is first time inserted in the year 1989, and some vehicles has been inserted by way of amended. So that provision brought under the act in the year 1989. So, the petitioner is liable to pay the one-time tax in respect of vehicle which was registered prior to the Amendment Act came into force. Keeping in view the judgment of the Honorable Apex Court. So there is no wrong in the judgment.
Very good. We'll reserve
Yes,
orders.
my lord.
We'll reserve orders.
Oblige.
Along with item number 43 to 50.
All the matters, my lords, item
Yes.
43 to now.
Lord, in some of the matters, my lord, in the meanwhile, the petitioners have transferred the ownership of vehicle. So in that case, my lord,
That is a principle
there is no-
decided, my lords. The judgment should report.
Supplementary list item 76.
My lord, in item number 76, Lordship may kindly see Lordship's order dated 17/11/2022. It is stated that some of the respondent have expired and application will have to be filed for bringing their legal representative on record. My lord, in the meantime, my lord, I have already filed the application for substitution.
Which IA number?
My lord, those are IA number
Third on the-
558 for limitation 559 respondent number 5 with respect to deceased respondent number 5 not brought on record. My lord, I pray let it come on record in some other date.
All right, the applications for substitution stated to have been filed are not on record. List on 1st May.
My lord, interim order to continue.
All right.
77.
But item 77, my lord, in this case, notice was issued as per my lord's direction dated 17/11/2022, my lord. In the meantime, respondent number 4 and 7 had died, my lord. May I be permitted to take steps for substitution, my lord? They are the contesting respondents, my lord.
All right. Respondents 4 and 7.
Noting has come.
Respondent
Respondent number
stated to
4.
be are
So also
shown to have been
respondent number
deceased.
9.
As shown to have been 4, 9.
My lord.
Respondents 4 and 9
Well, it's just
are
one.
stated to have expired. Counsel for the appellant is permitted to take steps to bring on record their legal representatives. List on 10 July.
78.
My lord, in the present case, petitioner challenging the judgment dated 5/9/2018 passed by the Honorable Single Judge in allowing the writ petition, that is Annexure 4, my lord. The main ground of the present petitioner that I have taken the stand at that is at D, my lord. The main, those 2 points, that is, it is pertinent to point out
Reconsider
that,
penalty, sir.
my lord,
What is so great? It's only to reconsider the penalty. Only remanded, nothing else.
no, my lord, the point they have added, my lord, the Honorable Court, though held that there is no violation of the natural justice and there is no infirmity remitted back. But the other part of the direction, my lord, that is specifically that the operation person of the that
It's only on punishment, sir, and for that limited purpose, it is remanded. What is
remitted face punishment in favor of the prisoner within the period of 3 months with interest of 6% per annum. That means the second, the first, another inquiry for which it has been held by this Honorable Court, that will affect that. So this Honorable Court should be kept for that. That is the case.
the challenge by the Union of India is to an order dated 5th September 2018, passed by the single judge, disposing of writ petition. Four 414 of 2003 filed by the respondent. Questioning an order passed by the commanded CISF unit Nalco and Gool, removing him from service. The reviewed order, while not interfering with the finding of guilt in the disciplinary inquiry, the learned single judge is interfered only as regards the proportionality of the punishment imposed, and has remitted the matter to the disciplinary inquiry to consider afresh the question of imposition of the punishment. Full stop. Having heard learned counsel of the appellant, the court is not inclined to interfere. Since the direction was only for reconsideration of the punishment in a time-bound manner. Stop. The court sees no prejudice being caused to the appellant on that scope. Stop. Further, with no stay having been granted by this court, the said direction ought to have been implemented by now. Full stop. If it has not already been implemented, it shall positively be implemented within a period of 3 months from today. The writ appeal is dismissed with the above directions.
Item 79.
Well, it's item 79. Last order, my lords, the state government was asked to give a report under section 16 of the Railways Act.
Yes.
As the report is still awaited, my lords may give me 2 weeks' time. I'll get the report on record.
My lord, here I am appearing for the respondent number 1 company. I don't have an objection to his seeking the time, but there's one application for vacation of stay. In view of the
He's not today asking for that.
Yes, my lord. In fact, I am at a peril because the entire slurry ash, which is to be deposited on the other side, has been now dumped in the premises of the power plant. So that will be a difficulty if the rains start. So, my lord, before that, this matter may be adjudicated. That is what my prayer is, my lord.
All right.
So,
We are appearing for the railway. We have already filed counter affidavit.
Where did you file it, sir?
Last occasion we have filed, we have already served copies also on 11/1/2023, 11 January. Man.
You were to file what, Mr. Martin?
Well, it's under section 16, my lords, a report is awaited from the state government to show that whether a box culvert is required at that particular area.
Paragraph 9.
On the last, in the last order.
Order dated 10/1/2023, my lord. There's a requirement under the statute, my lord. Prior, my lord.
Let me see the last order.
Opinion of the government is necessary before passing any order, my lord, for construction of box culvert.
All right.
That is.
You say Mr. Martin needs some more time for the state government to file a report in terms of section 16 bracket 1 bracket small a of the Railways Act 1989. Interim order to continue. List on April 20th.
if your lordship can observe that in case it is not, then the IA may be considered on that day.
Yes. After.
order. As an interim measure, the appellant, if already relieved, shall be reinstated and permitted to discharge his duty as a forester by adjustment against the available vacancy in the open category. And this was made pursuant to an assurance given by the paragraph 5. Till today, my lord, the reinstatement has not been made.
Yes, my lord, there is a problem that vacancies for women category. You are
File an
women.
affidavit. Once there's a direction, you have to
Yes,
file
my
an
lord,
application.
Yes, my lord, that we have to accommodate him at any cost, even if that is. So you'll also call this matter next week. In the meantime, we'll accommodate.
It is pointed out by Mr. Rathal and senior counsel for the appellant that the direction issued by this court on 14 December 2022 to reinstate the appellant as a forester by adjustment against the available vacancy in the open category has yet to be implemented. Paragraph Mr. Kuntial and additional government advocate seeks a short adjournment for instructions. List on 6th March.
21st.
6th March. Supplementary list passport matter item 51.
My lord, item 51, my lord, I'm sorry, I'm in virtual mode, my lord. May I audible, my lord?
Yes, yes.
Yes, my lord, there's the writ appeal they have filed in IA, which is required to file objection. Condonation. It is a condonation of delay. The writ appeal they have filed in IA.
Yes, the entire case of the petitioner, as your lordship's hearing on the last occasion, was that there were about 284 vacancies for the post of the constables. And thereafter, there were...
No. What is this delay?
Delay, there is some delay, my lord, in...
22. What is that?
My friend wants to file an objection to that.
No, this is not for delay. Oh, condone the delay. 80 days delay. You want to file a reply to that?
You have an objection is required, then file affidavit. Otherwise, I leave to the court, my lord.
Yes, yes. For the reason stated, the delay is continued. All right. So IA is allowed. Yes, sir.
Yes. There were 284 vacancies, and the petitioners were qualified and they have also appeared. That was in respect of 3 districts: Bolangir, Koraput, and Malkangiri. And for each district, some vacancies were there. So far, Bolangir is concerned, there were 24 vacancies, and earlier, after some selection, some writ petition was filed before this honorable court by so many candidates. We were also there. And there, during pendency of the writ petition, the central government has issued another list of the selected candidates. And in that list, and 10 candidates were selected. Out of that, only 6 joined. 4 have not joined. We are also qualified. Therefore, we have filed a writ petition saying that we may be considered for those remaining 4 posts. Before the honorable single judge, it was no counter was filed, but it was stated that the cutoff mark was fixed at 64, and we have secured 63 marks, and therefore we are not entitled. That is nobody's case, neither in the earlier writ petition nor subsequently.
Party, what are your instructions?
It was listed first time, we don't have an instruction, my lord.
You
copy I received yesterday.
Mr. Rao, that it was nobody's case that the selected candidates had secured a cut above secured 64 marks or above, which was the cutoff mark.
But there's a order shows that it's 63 marks.
When the writ petition was heard, we'll stop. Mr. Party states that he'll need to take instructions. At his request, list on 4th May.
Lakshmi reply along with Mr. Satyavrat Pandai JP.
the opposite respondents will file an affidavit specific to the above issue before the next date. Right.
Oblige, my lord.
Right.
Pastor matter item 57.
May I please, my lords. So this is a matter which is fully covered by your lordship's judgment in case of automobiles, which is affirmed by the Honorable Apex Court, my lords. If your lordship
No
will see
ground
the-
has been, no ground is there, my lord.
That's all right. That time they didn't know, sir.
So record has to be called for, my lord. We have to verify.
Yes, sir. It's not, my friend probably has not gone to record. Your lordship may kindly turn to page 51. Page 51, the reason of reopening. And my ground is at ground number D and para H of page 10. Page 51, my lords may kindly see for a while, my lords. Plus, second paragraph. The sales tax officer, STO investigation, Burville, submit tax report, so and so. Then the dealer has not been assessed under section 42 of the OVAT Act. So the returns filed under section 33 are accepted as self-assessed under section 39 of the OVAT Act. Since the tax evasion report is not material position, as well. So now therefore, because 42 assessment has not been made, so therefore return is accepted. And your lordship judgment specifically in paragraph 22 says there must be communication of that acceptance or acknowledgement of acceptance. Para 22 of my lord judge, fully covered, my lords.
That has to be verified, my lord.
So why I am surprised by my friend says it not mentioned. I have taken averment in paragraph H and also ground number D. It's there, it's a matter of record. You
2014 matters.
Yes.
You say present petition has been pending since 2014.
Yes, I'm giving a copy to my lord's judgment.
Yeah. One of the grounds in which the impugned assessment order has been challenged is that under section 43 of the OVAT Act is challenged that it was not preceded by communication by the department to the dealer of the acceptance of his self-assessment under section 39 of the OVAT Act. Stop. Till date, no reply has been filed in the present petition, although notice was issued way back on 23rd February 2015. Paragraph. It is seen from the impugned assessment order dated 20th November 2014 that the above fact is admitted by the department. Full stop. The relevant sentence reads, open correction. The dealer has not been assessed under section 42 of the OVAT Act. Full stop. So the returns filed under section 33 are accepted as self-assessed under section 39 of the OVAT Act. Stop and quote. Paragraph. It's not disputed that the acceptance of the self-assessment, acceptance of the returns by way of self-assessment has not been communicated to the petitioner dealer.
Para 22 of your lordship judgment.
Following the judgment of this court in case of automobile, which has been affirmed by the Supreme Court of India in Pratt Steel. This court quashes the impugned assessment order and the consequential demands. Consequential demand notice. The petition is disposed.
Item 60.
Deeply obliged. It's item 60 bills. Here bills the petitioner has challenged annexure 9 bills, which is bills an order passed under section 7(5) of the Orissa Income Tax Act, bills demanding interest bills. But the distinction between this case and the batch of cases you lordship have heard the other day, reserved for judgment bills. Because this order is passed prior to the judgment of the Honorable Apex Court. That is bills 9/10/2017. And this order is passed on 9/2016 bills. And secondly, bills, that is a case in batch of cases bills. Because being agreed with para 30 of this honorable judgment bills, state has filed appeal in batch of SLPs before the Apex Court. And here is a case, this is a lead matter, where Tata Steel being agreed bills has filed SL before the honorable Apex Court bills. But so far as the interest under section 7(5) is concerned, bills, this order is passed bills prior to the order of the Apex Court. And secondly, bills, what is more important is, bills, I have annexed a copy of the interim order passed in this case by this honorable court. The language of the order interim order, if my lords may, I have annexed 2 bills. One, I have given the Apex Court's interim order. And first of all, my lords may kindly see order by the annexure 1 at page 27.
Yes.
I will take my lord's attention straight to bills, page 31 bills. Page 31. In view of such, we direct the petitioner.
Yes.
Yes, in view of such, we direct the petitioner to file an affidavit declaring the goods which were imported by it from outside the country, along with the relevant documents, before the concerned assessing authority within whose jurisdiction the goods were brought in. The petitioners reflect the purchases and import materials which are brought from outside the country in its respective returns and amount of tax payable on the said account. The petitioner is allowed not to pay any entry tax on import materials now. But if it is found that the petitioner is liable to pay the tax, the same shall be paid by it. Plus, with this sort of mirrors, the petitioner was not paying mirrors, and subsequently, your lordship modified by directing the assessing authority to make an assessment. They made an assessment, mirrors I have filed appeal. Those are different route mirrors. I am not on that. And thereafter mirrors, this opposite party number mirrors 2, by the annexure 9, now has raised this mirrors. In the meantime, after the judgment of this honorable in 2012, my lords may kindly bear in mind, on 9/10/2012, the writ petition challenging the validity of levy of tax and import was dismissed by your lordship in Tata Steels and another versus state of Odisha. Whereas I filed SL before the Honorable Apex Court. Honorable Apex Court, your lordship may kindly see the interim direction. At page 5 minutes. Caption is that because it's a comprehensive order passed in respect of other companies, your lordship may confine to Tata Steel. SLP number 36187 of 2012, page 5. See, Harish Salve, senior counsel appearing for the petition on instruction, would submit that he is not seeking any interim order towards the past transactions and for the past demands. So, for the past demands is concerned, we don't have anything. We have paid and we don't have any. He would further submit that this court may grant him interim order towards the future demand that may be raised by the respondent authority issue. Sri Rakesh Dwivedi, senior counsel appearing for the respondents, also access to the request made by the senior counsel for the petitioner. Keeping in view the above, so far the first transactions are concerned, we are not inclined to grant any relief to the petitioner. Then, in so far as future transactions are concerned and the demands that may be raised by the respondents are concerned, the petitioner shall pay 50% of the aforesaid demands within a month's time from the date of demand. If for any reason the petitioner fails to comply with the orders and directions passed by this court, the respondent would be at liberty to recover the entire tax liability with interest and also the penalty. We make it clear that if for any reason the petitioner succeeds in these matters, the respondent authority shall refund the amount paid by the petitioner pursuant to interim order passed by us within 30 days from the date of the order with statutory interim order account. So now, my humble submission is, after the matter came to an end, in 2017, I have paid the entire tax minutes. Now the question is, the dispute before your lordship in this writ petition is, annexure 9, which is an order imposing interest. That is, of course, 7.5, there is no provision for passing any order. There is order imposing interest, which is prior to the Honorable Apex Court judgment, unlike other matters, and during the course of which all through I have been complying the interim order passed by this Honorable Court, and also Honorable Apex Court.
And annexure 9 amounts from first appellate's order, that is 49 of the writ petition. The first appellate authority remanded back, my lord, I am just placing page 49, my lord, para 15. In the result, the appeal partly succeeds. Tax demand is upheld and penalty is fully deleted. The appellant is directed to deposit the entire amount of tax along with interest by self-calculation after adjusting the amount paid, if any, after assessment. Since higher amount of tax has been deferred, the Learned Assessing Authority is directed to collect the tax and interest as per provisions of law. The appellant is also directed to cooperate the Learned Assessing Authority in recovering the due of the revenue. It amounts to annexure 9. Annexure 9, he has calculated how much he has deposited, how lately he has deposited, so interest has been levied.
This appellate order was also challenged by the petitioner before lordship in WPC number 6115 . There also ultimately it ended with the direction that you pay the entire amount, because there was earlier direction 50% . In the meantime, after Honorable judgment, yes, I paid the full amount. There was direction to commissioner, liberty to commissioner to approach that. I approached the land commission. And in the meantime, entire tax is paid. Now the question is not that. Question is whether prior to the judgment of the Honorable Apex Court, the 7.5 interest can at all sustain, whether sufficient cause subsist or not.
Correct.
For that, may I suggest one thing, not two things. Now that your lordship heard the matter, either this can be tagged along or
It will be tagged along. We'll reserve orders in this and we'll deal with it.
this can be.
Yeah.
Miles. Then your lordship may permit me, I will submit a small note as other field miles.
Orders reserved, both parties are permitted to file a short written note of submissions within 1 week.
Miles.
Grateful, my lord.
All right.
Pastor item number 11. 11. Sir.
I was placing the list of dates.
Yes.
Before I continue, I may indicate the ground that has been set out in the order is that I have completed the compliance 1 day late. That is on 29 June. They accept that in the counter affidavit. On 29 June, everything is completed. The date from which the 30 days period is to be counted is 30th May 2020. That is also not disputed. Under the General Clause Act, Section 9, if 30 days is counted from 31st, 30th will have to be omitted, 31st. Then the last day is 30 days period ends on 29. Assuming 30th is also included, 30th May, the last day is 28th June. 27th and 28th are public holidays, Saturday and Sunday. And this was during the COVID period, complete shutdown. 29th, I have completed everything, is admitted. In which case, the entire basis of the order goes. Now, if my lords will kindly see, I was on the list of dates. Kindly have a look at page 2.
Yes.
Page 1 last but one. 30th May 2020. State government issued vesting order under Rule 9A, thereby vesting all clearances approvals held by previous lessee in the petitioner. Period prescribed under sub-rule 6A, 6B of Rule 10 of Mineral Auction Rules 2015. 15 plus 15 days commence from here. I am assuming for this purpose that the Mineral Auction Rules 2015, which comes in the amendment made on 20th March 2020, applies to me. Although I have an argument that it won't apply to me, but I am assuming for this purpose, it applies to me. I asked for extension 10 June, 15 days, that is granted. Now let's kindly come to issuance of 12th June, granted extension, 15 June, I make this payment of second installment. 19 June, petitioner made payment towards net present value. Petitioner video letter dated 19/6 informed the state government about payment of second installment of upfront payment and net present value. 22nd June, petitioner requested Axis Bank for issuance of bank guarantee. 26th June, Axis Bank rejected request of petitioner for issuance of bank guarantee. Petitioner immediately applied before IDFC First Bank. 26th June, petitioner furnished a bank guarantee and wrote a letter to R1 seeking status of successful bidder under relevant rules for reason that it has fully complied with the requirement. Full compliance done by on 26. 27, 28, both these days were holidays on account of Saturday and Sunday. Further COVID lockdown was in effect. 29 June, therefore, I had made the payments, I had given the bank guarantee all by 26 June. 29 June is because I gave a letter on 29 June saying that I had complied with everything. Therefore, that is treated as the basis. Although I had complied with everything by 26 June. Petitioner wrote a letter to state government on 29 June in terms of 10.3 of Mineral Auction Rule.
categorically ascertain that it is in continuous compliance with terms and conditions of eligibility. Petitioner made payment of third installment of upfront payment. Petitioner wrote letter to Director of Mines seeking status of successful bidder and made payment of third installment, even though it was not yet due, as per Rule 10(5) of Auction Rule. As per provisions of Auction Rule, third installment of upfront payment is required to be made only after signing an execution of mine development and production agreement. It should be petitioner further informed that it has arranged liquidity. The Director of Mines wrote a letter to Secretary Steel and Mines noting complaints made by petitioner. In spite of that, nothing was done. Therefore, requesting additional personal audience, further direction for execution of lease deed. All this goes on. I will skip all that. Yes, 31st July, petitioner wrote a letter to the state to the state government that yes, 30th July, the IA filed by the earlier lessee was withdrawn. SL Mining was withdrawn, and therefore I said now there is no bar to execution of the lease. Therefore, please execute the mining lease. Everything was completed. I had completed 31st July, 30th July. The Supreme Court bar also goes. Then I withdrew. It's not necessary. 20th August. This is where the state government issues show cause notice asking as to why letter of intent should not be revoked and all installments of upfront payment along with bank guarantee shall not be forfeited. I don't know, there seems to have been a change of mind by this time by government and the show cause notice is issued, although according to me, I have complied with everything. I replied on 26th August. Now, please see curiously what happens thereafter. 9th December, meeting was held between Union Mines Minister and Chief Minister of Orissa, wherein it was discussed to open central and state government companies for production of mineral from auction mines which are not in operation. 10th December, in continuation of above meeting, state government recommends reservation of subject mineral block. 21st December, high-level committee meeting was held to deliberate on reservation of subject mineral block under section 79. 22nd December, now, please see, high-level meeting takes place on 21st December. 22nd, the order is issued to me, revoking letter of intent and forfeiting all installments of upfront payment and bank guarantee. Today, whatever might have happened in regard to reservation, section 17A, it has been given to OMC. OMC has been operating the mines. They have successfully excavated considerable amount of mineral. My going in there doesn't serve any purpose. Even if I succeed, it will be a very quick hit. It doesn't make sense. But surely...
You want the return of your money.
I want return of the money with interest. Otherwise, this will be completely unjust. So far as I am concerned, please see the order, the reasoning in the order. I respectfully submit that this is not an order which can really stand. Yeah. Page 118. Yes, it starts earlier. Yes, at page 112. But please come to straight away, page 118.
Yes.
Yeah. Last but one paragraph.
Yes.
Whereas vesting order having been issued on dated 30th May, time period of 15 days as provided under Rule 10(6)(a) expired on 13 June 2020. And that as provided further under proviso, said period has been extended to the maximum permissible period of 15 days for execution of mining lease deed. This extended period also expired dated 28 June. Number one, this calculation is wrong because 30th May, 31st is one day, and 13th June, it can't expire. Therefore, they are including 30th May also. Section 9 of the General Clause Act is clear. When it says from, that day will have to be excluded. But I'm proceeding on the basis, even this 28th June, assuming it is the last day. 28th June is a holiday. Section 10 of General Clause Act says, if the last day is a holiday, then the next day will have to be treated as a day on which I have to complete it. Whereas 27th and 28th June were holidays, being respectively fourth Saturday of the month and Sunday. These days are holidays in the state, otherwise also, irrespective of the pandemic. Signing of MDP and execution registration of mining leases, granted, have been done by some other LOA holders on the day of holiday, namely 27/6. These LOA holders were no differently placed than the noticee. Whereas further notice reported on 26 to Director of Mines with complaints with regard to deposit of second installment, BG towards performance security and payment of NPV with Campa, and stated that it has complied with all the conditions stipulated and vesting towards so and so. Whereas our notice by the subsequent letter dated 29/6 intimated to Director of Mines that it confirms as required under Rule 10(3)A, we continue to be in compliance with all terms and requested to designate it as successful. This letter has been received from Director of Mines. Whereas has filed initially 2 IAs, those are not relevant. Kindly now come to page 120 middle. Whereas as provided under Rule 10(3), the preferred bidder shall be declared a successful bidder upon, among others, continuing to be in compliance with all the terms and conditions of eligibility. To this effect, the noticee has conveyed the confirmation only. I don't have to give a confirmation. I have complied with everything. Therefore, I don't have to give a letter on 29/6 by its letter dated 29/6, wherein it has confirmed, in continuation to its letter dated 26/6, that as required under Rule 10(3)A, it continues to be in compliance with all terms and conditions of eligibility. Thus, the full compliance is done by 29/6 only for the purpose of declaring it a successful bidder and not by 26/6. This again is wrong reasoning. Everything had been done on 26/6. I confirm by a letter that I have confirmed that I have complied with everything. Therefore, that is treated as compliance. But even if that is to be treated, that is done on 29/6. Therefore, Miller, I respectfully submit. Yes, now Miller, kindly see the final reasoning. Page 122. Whereas, presuming, for the sake of argument only, that the last date for complaints was dated 29/6, which is however not so for the findings above. Notice was required to complete the entire process within working hours of the day only up to execution of lease deed, which involves signing of MDPA after being declared a successful bidder, the collector concerned. Payment of third installment of upfront payment and thereafter grant of mining lease by state government on transmission corporation of such details, followed with payment of duty, registration fees by notice, and finally the execution of lease deed with the collector concerned. This entire process would not have been possible to be completed on a single day. How am I to be faulted on? And on this ground, the entire amount, at page 125, the order is passed, revoking the letter of intent, forfeiting the amount of 90 crore which had been paid upfront payment and performance security of 90 crore above penalties with surprise. I respectfully submit this is completely untenable, unjustified, and it's a onerous. The termination, the revocation of the LOI is onerous, and forfeiture in any case, I respectfully submit is onerous. This can't be justified. Yes, kindly now see page 128. My letter of June 26. Para 2, we would like to bring to your notice that we have already paid a sum of rupees 90 crore, etc. 9 crore, 6 lakh, towards second installment of 10% as per condition, same is already intimated. This was paid on June 15. Please also refer to letter dated June 11 for forest, paying net present value, reminders, 27 crore. We have already paid the same by the Treasury Challan dated June 19. We are also furnishing here with the performance bank guarantee for an amount of 90 crore 60 lakh. Accordingly, we have complied with all the conditions as stipulated in the tender document and vesting order. This is done on 26. Now, at 29, the letter, page 206. This now is treated as showing compliance. This merely says in continuation of our letter, page 206, we confirm the following as recorded under Rule 10.3. We continue to be
page 209.
209.
That's the challan for making the payment of 45 crores.
Yeah.
That you did on 29 June.
No, that was not occurred.
That stage has not yet come.
That stage comes later.
No. Just come to Annexure 30, page 209.
209. Yeah.
This payment, whatever you've made, this payment you made on 29th June.
This is the third installment.
That's right.
No, that has to be made at the time of execution of the lease. I had made advance payment. I have paid in advance. That is what I had stated. This comes later. I have paid in advance. And even so, let me assume, even that is done on 29 June. Well, I am not required to pay this. Please see, that is not the reason. Please see, yes. Kindly similar, this is not the reason given in, because this is an advance payment. In the order, there is no reference to this as the reason for it. This payment is an advance payment, which I need to do only later. Therefore, today, I think the state government perhaps had a change of view, whatever reason, having auctioned it. They perhaps wanted to have a reservation under 17A for OMC. Today it has happened. They have even.
This page 114.
Yes. Yes. Whereas LOA holder, my lords are referring to that paragraph.
Yes.
Whereas LOA holder deposited second installment of upfront payment and also BG towards dated 26 within 26/6. It failed to comply with the prescribed requirements in full within the extended period of compliance declared.
What do they mean when they say this?
No. Please see next sentence. In fact, LOA holder completed full compliance for consideration to be declared a successful bidder only on 29/6, inter alia confirming by the letter. Because I gave the letter on 29/6. But 26/6 I had given a letter. My lord saw that. There I had confirmed. How can 29/6 letter be said? I was merely reaffirming on 29/6 what I had said on 26 June.
All right.
And that can't be used as a ground for.
All right. Should we hear the yes.
May please, your lordship.
Yes.
They have made the following payments. My lord, one, they have paid 9 crores.
Yes.
And I'll tell you, lordship, what it is. And one more 9 crore. 9 plus 9 is 18. And 72 crores in one installment. And they have given a bank guarantee of 90 crores. So therefore, my lords, they have paid 90 crores payment and 90 crores bank guarantee. And they have given 27 crores as NPV. That is to Mr. Padi's client. That is to the Union of India for Forest. So we are concerned now with this 90 plus 90. Your lordship, just take the rules. There is a rule called Mineral Auction Rules 2015.
NPV, I'm told, has been refunded.
It has been refunded.
NPV.
Okay. If your lordships kindly have, my lords.
Yes.
Page 356. It is Rule 10.
Yes.
I will give another book. I think my lord Justice Raman does not have this. Hey, button, lord.
Here we have. It's all right.
No, we have an extra book.
All right.
If my lords kindly sees Rule 10, page 356 in my book.
It is called Mineral Auction Rules 2015.
Right.
Now, my lord, grant of mining leases. The preferred bidder shall submit the first installment being 10% of the upfront payment as per Rule 11. So, no issue that they are the preferred bidder. So, the first installment was 9 crores. On receipt of the first installment of upfront payment, the state government shall issue a letter of intent to the preferred bidder. So, that also was complied. Now, kindly see 3 minutes. The preferred bidder shall be considered to be a successful bidder upon continuing to be in compliance with all the terms and conditions of eligibility. B, payment of second installment of 10%. So that is 9 plus 9, 18 of the upfront payment, which they have paid. Furnishing a performance security as specified in Rule 12, that is that 90 crores bank guarantee. Satisfying the conditions B of subsection 2 of 5, your lordship may leave that minutes. Provided in case of auction, your lordship may leave all that. So now he was a preferred bidder. He got a LOI, and then to become a successful bidder, whatever was required to be done, he did. Now, what was but where he didn't do was the successful bidder shall sign a MDPA. 4. Lordship may have 4 minutes. Lordship may have 4. Sub-rule 4.
Yes.
The successful bidder shall sign the MDPA and production agreement with the state government upon obtaining all consents, approvals, permits, no objections alike, as may be required under the applicable laws for commencement of mining operation. So you have to sign a MDPA agreement with the state government. And 5, the successful bidder shall pay the third installment, being 80% of the upfront payment, subsequent to execution of the MDPA, and upon such payment, the state government shall grant a mining lease to the successful bidder. My lord, we are stuck here. On 29th, the 30 days expired. 28th it expired. 28th being a holiday, let us say 28th, 9th it expired. So by 29th, under the relevant rules, they had to first sign a MDPA, pay the balance amount, and then get a lease deed. So here, what did not happen was no MDPA was signed. That 72 crores should have been deposited after signing of the MDPA, and that would have entitled him to get a lease. And what happens if this is not done? You lordship may kindly see 6B over the page. My lordship, have it not? 6B. Yes. The holder of a letter of intent shall comply with all the requirements to execute the mining lease within the period referred to in subsection 6A. Your lordship may take it to be 30 days. Failing which, the letter of intent shall be revoked, and the bid security or performance security, as the case may be, and any installment of upfront payment paid shall be forfeited, and the preferred bidder or successful bidder may be debarred. So, my lord, what happened is, it's our case.
There's a proviso.
Yes, my lord. Provided that on receipt of an application from a holder of a letter of intent, the state government may extend the period of execution of the lease deed for a further period not exceeding 50 days on the satisfaction that the delay. So these 15 days he has already got. So 15 plus 15 is 30. 28, 30 days expired. 29th, without signing MDPA, he pays 72 crores.
No, but MDPA is to be signed. How does he sign the MDPA without your allowing him to do that?
No, but I'm only bringing the facts to your lordships.
No. What happens? No, we'll have to see whether this non-signing of the NDPA was a unilateral act by him deliberately, or it required two people to get together to sign. That's all. If you refuse to, put the MDPA before him for signing, and then you say, no, you didn't sign the NDPA, so sorry, tough luck. What does that mean? That's the only question here. Because admittedly, even in your own order,
yes, sir,
you have clearly said that that date expired on 28th June.
28th is a holiday.
So
it had to go to 29th.
Noted that. You noted that.
Lordship.
Yes.
Right. We have also said that if assume it 28 goes to 29th also,
yes,
you have not signed the MDPA.
That's right. So
and having not signed the MDPA, you still pay 72 crores.
So he has complied with that also. He didn't wait for MDPA to be signed to pay. So who's to be MDPA non-signing?
But I have to go by what I see. I can't go beyond that. I am here to assist your lordship.
That's right. In that case, you have to return. All right. We'll dictate it right away. You see, the challenge in the present petition by Messrs.
My lord, only one line.
Yes.
Would your lordship then note, my lord, his challenge to OMC's grant is not pressed.
I will give up.
He said
I'll
that.
give up.
He
That
said
your
that.
lordship may record.
Correct. Mrs. Shab Ors Jharkhand Private Limited, bracket SOGPL, is to an order dated 22nd December 2020, passed by the OSD cum Additional Secretary to the government in the Department of Steel and Mines, Government of Odisha, disposing of a show cause notice, bracket SCN, dated 20th August 2020, issued to SJOPL. And revoking the letter of intent, bracket LOI, dated 2nd March 2020, issued in favor of SGOPL, and further ordering forfeiture of all three installments of upfront payment, totaling rupees 90, 60, 13,852, and also the bank guarantee, bracket BG, bracket, towards performance security of the same amount. Full stop. While directing notice to issue in the present petition on 6th February, on 18th November, on 8th July 2021, no, you say before this, you say while this writ petition was pending, just before that you say, following the above order dated 22nd December 2020, the central government on 5th January 2021 granted prior approval under section 17 capital A bracket 2 of the MMDR Act, right? Of the Mines and Minerals Development and Regulation Act 1957, bracket MMDR Act, bracket. Reserving the mineral block in question in favor of the Orissa Mining Corporation Limited, bracket OMC Limited. Full stop. On 6th January 2021, Government of Orissa debarred SOGPL from future auctions of the said mineral block. Full stop. On the same date, OMC issued a notice inviting tenders for mine operatives in respect of the said mineral block. Full stop. Paragraph. The present writ petition was filed assailing the aforementioned order dated 22nd December 2020, as well as the letter dated 6 January 2021 issued by the Government of Orissa, debarring SOJP and the OMC's NIT dated 6 January 2021. Paragraph. It appears that on 11th January 2021, a mining lease was executed in favor of OMC Limited. Paragraph. When this petition was listed before this court on 12th January 2021, the following order was passed by this court. Reproduce the whole order. Paragraph. At the hearing of the present petition on 18th November 2022, a statement was made by Mr. C.S. Vaidyanathan, when the senior counsel appearing to the petitioner, that the petitioner open petition would like to confine the prayer in the main writ petition itself to the return of the forfeited amount. Full stop. However, the petitioner, even for that purpose, insisted on pursuing the challenge to the impugned order dated 22nd December 2020 of the state government. Full stop. Paragraph. Today, Mr. Vaidyanathan, while reiterating the above submission, pointed out that in terms of the proviso to Rule 6 capital B of the Mineral Bracket Auction Bracket Rules 2015, SOJPL had applied to the state government seeking extension of 15 days 10 bracket 6 capital B for complying with the requirements after having declared single quotes preferred bidder pursuant to the NIT issued by the Government of Orissa on 6th December 2019 for grant of mining lease in respect of the Jilling Langlota iron ore block. Full stop. By this time, it had already made payment of the first installment of rupees 906,01385 on 19th February 2020, conveyed on 16th March 2020 its in principle acceptance of the LOI, and on 31st March 2020 its unconditional acceptance of the LOI. Full stop. Paragraph. On 12th June 2020, the state government granted extension of further 15 days under Rule 10 bracket 6 capital B of the Mineral Auction Rules 2015. Following which on 15th June 2020, SOJPL made payment of the second installment of rupees 906,01385 of upfront payment. Paragraph. At this stage, no, full stop. On 19th June 2020, SOJPL informed the Director of Mines, Bhubaneswar, Odisha, that it had transferred a sum of rupees 2771,46,750 as payment of net present value paragraph. The petitioner states that on 22nd June 2020, it had approached Axis Bank for the issuance of a BG, which was required to be furnished by it. For the sum of rupees 90,60,13,853 towards performance security. Full stop. After Axis Bank rejected the request on 26th June 2020, SOGPL applied to the IDFC First Bank, and on the same date, by a letter, informed the Director of Mines of all the compliances it had made till that date, namely the payment of the first installment comma, the payment of the NPV payment of the first and second installments, the payment of the NPV, and the furnishing of the BG. Full stop. In para 5 of the letter, the petitioner informed the state government that it had complied with all the conditions as stipulated in the tender document and the vesting order towards the subject mine. Full stop. It requested to be declared as the successful bidder so that it could proceed with the necessary formalities for execution of the mining lease. Paragraph. As it transpired, the period of 15 days expired on 28th June 2020, which happened to be a Sunday.
The Lordship said 30 days. 30 days expired.
30 days expired on 28th June 2020. Full stop. The next working day, that is 29 June 2020, the petitioner wrote a letter to the state government reiterating that it had complied with all the requirements and making full stop. Further, the petitioner made an upfront payment of third installment in the sum of rupees
72 crores. 72
Yeah.
crore 48 lakhs.
Yeah, 1 minute.
Recorded at page 114. 72 crore 48 lakh 11,082.
$72,48,11,082. Even before any demand was raised in that regard. Full stop. On the same date, that is 29 June 2020, the Director of Mines wrote to the Special Secretary to the government, Nodal Officer, Steel and Mines Department, informing him of the above developments. And asking him to, open quotation, consider taking up the matter, unquote, for declaring SOJPL a successful bidder of the aforementioned mineral block under Rule 10(3) of the Mineral Auction Rules 2015. Paragraph. Although the petitioner was in correspondence with the government regarding execution of the lease deed, on 20th August 2020, an SCN was issued to it by the state government, asking it to show cause why the LOI should not be revoked and all installments of upfront payment along with the BG not be forfeited. Full stop. the petitioner replied to the SCN on 26th August 2020. Full stop. Ultimately, the impugned order dated 22nd December 2020 was issued by the OSD cum Additional Secretary to the Government, Steel and Mines Department. Forfeiting, revoking the LOI issued in favor of the petitioner and forfeiting the 3 installments of upfront payment totaling 90,60,13,852 and also the BG of the same amount. Paragraph. Mr. Vaidyanathan submitted that with the 15-day extension granted by the state government expiring on 28 June 2020, the petitioner had already complied with all the requirements on 26 June 2020 itself. Full stop. On 29 June 2020, it's ready for the execution of the, what does MDPA expand as? Mine Development and Production Agreement. Yeah, of the Mine Development and Production Agreement, bracket MDPA, as well as the Mining Lease Deed. Stop. In fact, it had made payment of the 3rd installment, which was required to be made only after execution of the lease deed. Full stop. Therefore, on its part, the petitioner had complied with all the requirements, and therefore there was no justification for the impugned order to be passed, revoking the LOI and forfeiting all the payments and the BG furnished thus far. Paragraph. Mr. Ashok Parijal, Advocate General, drew attention of the court to Rule 10, bracket 4 of the Mineral Bracket Auction Rules 2015, in terms of which the successful bidder was to sign the MDPA with the state government upon obtaining all consents, approvals, permits, etc. Full stop. The consequences of the failure to make payment of the installments and sign the MDPA was spelled out in Rule 10, bracket 6, capital B of the Mineral Auction Rules, which reads as under. Just reproduce 10, bracket 6B. Mr. Parijal submitted that although the 30-day period expired on 28th June 2020, by which date the petitioner had paid the 2 upfront installments of 10% and also furnished the BG. It had not yet signed the MDPA, which was mandatorily required to be done. And therefore, the impugned order noted that the petitioner had failed to comply with the open quotation prescribed requirements in full within the extended period of compliance, unquote. Paragraph. The above submissions have been considered. Full stop. What does not appear to be in dispute at all is that after extension granted by the state government of 15 days for the petitioner to comply with the requirements of Rule 10 of the Mineral Bracket Auction Rules 2015, the total period of 30 days expired on 28 June 2020. Full stop. In fact, the impugned order itself notes this fact. Full stop. There is also no dispute that with 28 June 2020 being a Sunday, technically, the petitioner could have even shown compliance of the requirements on 29 June 2020. Full stop. However, as noted by the impugned order itself, the petitioner not only paid the 10% upfront installments, but also furnished the BG of rupees 90,60,13,853 by 26th June 2020, that is at least 2 days prior to the expiry of the 30-day period. Full stop. The petitioner on its own even deposited third installment of the upfront amount on 29 June 2020 without any demand being raised in that behalf. Full stop. This too is noted in the impugned order. Full stop. Under Rule 6 capital under Rule 10 bracket 4, it is only after the petitioner is declared as single quotes successful bidder that it is required to sign the MDPA and the mining lease agreement. Full stop. The petitioner, having complied with all the requirements on 26th June 2020 itself, and having written to the Director of Mines on that date about such compliance, it was incumbent on the state government to have made the next move of declaring the petitioner as a successful bidder and then placing the MDPA before it for execution. Full stop. That somehow never happened. Full stop. The state government did not invite the petitioner on 29 June 2020 to execute the MDPA and the mining lease. Full stop. In other words, there was nothing further to be done by the petitioner on 29 June 2020, since all its obligations till that date had been complied with by it. Full stop. It was the state government which was required to get the petitioner to execute the MDPA and sign in the mining lease. Full stop. The impugned order is silent on this aspect when it says that the petitioner failed to comply with the prescribed requirements in full. Full stop. In the above circumstances, it cannot be said that the petitioner failed to fully comply with all the prescribed requirements within the stipulated deadline for being declared as a successful bidder. Full stop. Consequently, the court sets aside the impugned order dated 22nd December 2020 to the extent that it forfeits all the three installments of upfront payment totaling rupees 90,60,13,852 and also the BG towards performance security amounting to rupees 1960,13,853. Full stop. The court directs the government of Orissa to return the aforementioned sums to the petitioner, together with simple interest.
The amounts have been invested, I believe, in the page. In my Lord's order of 12th January, my Lords have noted the prayer that the amount may be kept in an interest-bearing account. So whatever is interest,
right.
Yeah.
All right. Together with the interest that has accrued thereon, as
That was the order, interest bearing account.
Interest.
Yeah, separate interest bearing account, right?
Which order was this?
12th January. Our state planning.
No, that was the submission made, I think. That was Mr. Raval's submission.
That was a submission. Minutes.
This was our submission.
Yes, yes.
But I understand that it has been kept in by the state.
No, my lord, there was only a submission of Mr. Raval.
Okay, all right. Together with whatever interest that may have been accrued thereon, in the event,
yes, yes,
the amounts have been kept in an interest-bearing account, and if not, together with simple interest.
No, what you may not say interest, state and interest. I would request your lordship. Lord, interest is a little harsh on the state.
Wow, that's harsh.
I think
it's
it's
a huge amount of interest.
Simple interest of whatever my lords
interest is
I won't ask for 12%, your lordship may give 6% simple.
6% simple interest from the date of forfeiture of the amount, that is 22nd December 2020, till the date of its payment, which should not be more than 8 weeks from today.
Lordship is simple interest.
Simple interest.
Simple.
If the payment is not made within the time stipulated, the state government will be liable to pay.
Yeah, Lordship will leave that. It will happen.
9% per annum for the period of delay. That's all. So that it gets paid within that 8 weeks.
My lord, that other writ petition, your lordship may protect me. That OMC, I don't want to.
Okay.
OMC writ petition is not pressed.
All right.
No, that we won't.
Writ number 1816.
Okay. In view of the order passed, in 1816, you see now, view of the order passed today, in writ petition 889 of 2021, Mr. Vaidyanathan says that he's not pressing the present petition and it is disposed of as such.
Lordship, please.
Grateful.
All right.
Here the where the pin number 2, 1 and 3.
Yes, yes. All right. All right.
Grateful.
All right.
Okay.
This way. We'll continue from where we left off.
Weekly list, item number 29.
Plus, this is regarding the lease of the land, my lords. In the last occasion, your lordship was pleased to plus ask the land state council to take instruction regarding the status of the revenue case number 60 of 83 pending before the collector Kalahandi, your lordship.
I was wondering whether it could still be pending for 42 years or 50 years or something,
Yes,
right?
my lord.
83. Yeah, 40 years. Some more time.
This is 40 years old matter. This time I will get the instruction
All right,
at any cost.
All right.
2 weeks time may be granted.
We'll call it on Monday next. We'll just keep
Monday.
stay on board. Monday next, we'll call it.
No, I have to send the letter. They will sort for it. Will take some time. Lordship may fix
Send
another
an email,
day.
sir.
In regular list. In regular list, it may be.
Just send an email.
This Tahsil office,
You're all supposed to be fully connected now.
No, I can, but it is from the Tahsil office of remote areas. So, anyway, if your lordship say, I will keep. Yeah. It may be
We'll
stay
have
on
to take it to we'll have to,
next week.
next week, let it come up on Monday. Next week.
Yes.
Interim order to continue, Millers.
We're not passing any order. It'll just continue. That's all.
Millers.
So, Mahanti, you can even try on phone. You can try to contact the Tahsildar by phone. He'll tell you immediately because it's only a petition number is also given.
Yes.
Case number is given.
We'll take it up on Thursday.
Yes.
Yes, madam. Yes, ma'am. Today I am trying to contact. Yes. I will try my level. I will get it.
All right.
No, I will get it.
Right.
Weekly list old matter item number 30.
31, no instructions. No instructions dismissed.
We are for the union.
Right.
Item 31.
No instructions.
No instructions dismissed. All right.
Item number 32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
34 not press, my lord.
Not press dismissed.
Only. Item number 35.
Minutes 35. Because I filed a order, a similar copy of the order on 13/2/2023.
Yes.
Exactly similar case of this honorable court.
Your lordship, item number 34, the name of Mr. S.B. Jana for the opposite party may be recorded.
All right. This is one of those cases that subsequent
demand.
Right. On the short ground that the petitioner, being the subsequent purchaser through a registered sale deed, was not issued notice by the Additional District Magistrate Bhubaneswar while passing the impugned order, cancelling the lease grant to the petitioner's vendor, the impugned order dated 19/9/87 of the ADM Bhubaneswar is hereby set aside, and revision case number 695/1987 is restored to the file of the ADM Bhubaneswar, where it will be listed for hearing on 17th April 2023. Stop on that date, the petitioner will appear along with the downloaded copy of this order. The ADM Bhubaneswar is requested to proceed afresh in accordance with law and dispose of the said revision case within a period of 4 months thereafter. Till such time, the status quo as of today shall be maintained.
Item number 36.
None appears dismissed.
Item number 37.
None appears dismissed. The memo is taken on record. Dismissed as infractious.
37, my lord?
Yes, dismissed as infractious.
Item number 38.
None appears dismissed.
Item number 39.
It's regarding a custodial death, my lord. This happened in 2010. And this is tribal, the victim is a tribal, leaving 5 children, 5 minor children. And it is admitted that during the interrogation, they say it's during interrogation, he succumbed to death. She was carried to the hospital where she was found dead. As I have prepared a short death chart, my lord. On 23rd May 2010,
Yes.
husband of the petitioner, namely Pidera Kaderka, along with a co-tribal, Mandamaji, went to forest in search of firewood. In the same day, that's OP5, along with his companions, caught hold of the husband of the petitioner, Mandama and Mandamaji, and brought them to Chandrapur police camp. And in the same day, 23rd Feb, husband of the petitioner and Mandamaji were assaulted inside Chandrapur police station by the police personnel by means of backside of the gun, lathis and kicks. Then on 27th Feb, Mandamaji was let off from the police station by instruction of the SP Raigadi. The person who accompanied the victim, he was let off. On 2/6/2010, Raigada police station case number 109 under section 121, 121A IPC, read with section 25, 27 Arms Act, read with section 3, 4 ES Act and 17 UAP Act, read with section 17 Criminal Law Amendment Act, registered against the husband of petitioner on the written report of opposite party number 5, that team in charge, to the IIC Raigada. On the same day, that is 2nd June 2010, UD case number 10 of 2010 at Raigada PS was registered on the death of the husband of petitioner.
UD means?
UD case, my lord. Unnatural death.
Unnatural death.
My lord. On 3rd June, IIC Chandrapur PS gave a message to the Sarpanch of Chandrapur, namely Subhas Maji, to come up to PS urgently and meet the SP Raigada. On the same day, the Sarpanch Subhas Maji and another George Kadeska went to the IIC Chandrapur PS, who brought them in a commander jeep to Raigada SP office, where the additional SP informed about death of Pidera Kadeska. On the same day, inquest report of Raigada PS case number so and so in respect of the dead body of the was prepared. On the same day, also postmortem of the dead body of Pidera Kadeska was conducted in DHH Raigada. On 3rd June, additional SP Raigada insisted Subhas and Josh to bury the dead body of Pidera Kadeska instead of carrying the same to their village. On 3/6, dead body of the Pidera Kaderka was brought to the village where it was buried as per tradition of the tribal Christian community. Then on 7/6, grievance letter from the villagers under Chandrapur block was addressed to the collector Raigada, claiming rupees 10 lakhs for the deceased family with 5 acres of agricultural land, permanent employment in government services to the member of the buried family, facilitation education of the children of the deceased, postmortem, 4 acres of land for house, etc. Then press release of PUCL team went and they released a press meet and reported on death of the Pidera Kadeska. On 28/6, magistral inquiry was conducted on the death of Pidera Kadeska. Then on 3rd July, no metallic poison or viscera, on the viscera test, no metallic poison was detected in the viscera report. On 19/9, Chandrapur PS case number so and so under the aforesaid sections were registered against the husband of the petitioner, my lord. This is the short background of the case, my lord. Here, my lord, while in custody of the police, my lord, it is undisputed that the victim expired, my lord. And in the post-mortem report, though they say that there is nothing, in the post-mortem report that was submitted in the counter at page 44 of the counter, Lordship may see, page 45,
All swollen.
Counter filed by OP number 3, the post-mortem report.
Blood from both nostrils. Yes.
Lord, there in the postmortem report at 45, serial number 6, whether rigor mortis present. It is stated rigor mortis was present in both lower limbs. Then in the very next page, as page 46, so rigor mortis was present in both the limbs, and thereafter under clause 7, pennies were swollen. Pennies were swollen. Blister set were present in the different parts of the body. Then, my lord, eyes were closed. Both the lungs, both the eyes were,
Both the lids of both eyes was
both the limbs and both the eyes were swollen. Then passage of stool from anus were present. Then blood
tinged froth.
Blood tinged cloth from both the
froth.
Yes, present. Tongue was protruded.
Right.
And column 8-2, old healed abrasion over right buttocks more than 7 days old and size of the swan shoulder. In the next page, my lord, page 47, at column C, subclause B, subclause E, orbital, nasal and oral cavities findings. Blood-stained fluids were present in the nasal cavities. Orbitals around cavities were normal. Look, these are the reports, my lord. And the other also, page 48, lungs findings, my lord. It is taken black colored deposits in both lungs are present, my lord. And then again in 4, abdomen, no abnormality except blister over the abdomen wall. Then in the last line, penis and scrotums were swollen. These are the reports of postmortem reports. Here in the last page, the magisterial inquiry report reveals at page 58. Lordship may see page 58 of the same counter. This is the points or information for the customers. This is magisterial inquiry report, my lord. Here in column number 5, place, date of time of arrest. He was taken to custody on 1/6/2010 at 9:30 p.m. being caught inside Tagapunial forest near village Togapankal and handed over at anti-Naxal cell Raigada on 2/6/2010 afternoon at 4:30 p.m. covering 25 to 30 kilometers by walk and 80 kilometers by vehicle. Then in the next column 6, police officer who carried out the arrest by SI Bhanushankar Yadav in charge of SOG team, camp at Raigada and SOG staff. He has been arrested as the opposite party number 5 in the case. Then in column 12, place, date and time of taking into custody. They admit that on 1/6/2010 night at 9:30 p.m. And in the next column, whether medical examination was conducted. If yes, enclose the copy. If no, then the reasons. No. Since the deceased, while taken to custody, had received no external injuries on his body, and since the deceased has not complained of any pain on his body, he was not medically examined. But while under interrogation at 5 p.m. on 2/6/2010, he suddenly fell ill and became unconscious. He was immediately shifted to district headquarters hospital Raigada for medical treatment, where he was received dead at 5:20 p.m. So this is the background. Now,
went to the spot. They have given their report at Annexure 2, my lord. They have categorically, they have asked the police officer, the magistrate, as well as the villagers, and they came to the finding, my lord, at page 14. Page 14, second paragraph, my lord. However, the IIC Raigada Thana gave on the following information based on the findings of the post-mortem report on the body of Pedera. Both sides of the hearts were empty, black color deposits found in the lungs, swollen genitals, and a mark of wound, 6-7 days old, and 5 cm into 2 cm in size in his buttock. The conclusion as to the immediate cause of death has been kept, result pending histopathological test of viscera. A magistral inquiry has been conducted by Raigada Tahsildar and a report sent to the National Human Rights Commission. Then in the next second para, on 23rd May, Vidya had gone to the nearby forest for shooting birds with a desi gun, commonly used by Adivasi for hunting birds and small animals. Vidya met Mandhamaji Jurengar of nearby Trimaka village, who too had come for the same purpose and was carrying his gun. On that day, both of them were caught by CRPF combing in the forest area. They were beaten up and taken to Chandrapur as Naxals. At Chandrapur police station, they were again beaten up. Mandhamaji was let off after being kept in CRPF camp for 4 days, while Pidera was taken to various places till he was brought to Raigada on 22nd June, my lord.
2nd June.
22nd June. Where
Not 22nd, sir. Second.
it is, sorry, 2nd June. Then Mandhamaji and several eyewitnesses attest that Pidera was brought to Chandrapur police station on the day he was caught by CRPF. George Kadarka, an uncle of Pidera, who lives in Chandrapur, came to the police station after hearing that Pidera had been caught by the CRPF and brought to the police station. There he saw Pidera being kicked around and beaten by the CRPF people. He was asked by the local police. Basmaji, the Sarpanch of Chandrapur Gram Panchayat, who corroborated the fact that Pidera was caught to Chandrapur by the CRPF on 23rd May. So, my lord, on 23rd May.
How does it? No, just tell me one thing. CRPF bring him to the police station.
No, they controlled. That is the.
We file a one-page affidavit explaining therein that this opposite party number 5
belongs to SOG.
SOG.
They say that it's not CRPF but the Special Operation Group assistant
of the state government.
State government.
So it's not CRPF.
No. In our counter, we have structured at Para 3. From 23rd, he was in custody of the police personnel. And they admit that they have arrested him on 1st. And on 20th and on 2nd, he was found dead. Leaving behind 5 minor children.
So what do they say in their counter, state government?
Because we have said that he was, let's read.
Died due to natural causes.
Yes, Milad.
The standard thing.
Let me see page 51.
Yes.
This is a letter from the IIC Rayagada requesting the doctors at the district headquarters Rayagada to opine on the cause of death. I'll read that letter. With reference to above cited subject, I'm to inform you that on so and so, you conducted autopsy over the dead body of deceased Pidera Kadesra at district hospital. In the PM report, was kept pending regarding the cause of death for histopathological and chemical examination of viscera. Accordingly, viscera were sent to SFSL Rasulgarh and pathology department for the above purpose. After examination of the viscera, both the organization have opined their opinion. Under the above circumstances, I have sending here with the Xerox copy of the said opinion for your kind perusal. Now, after going through this on page 56, the the two doctors, BLN Prusti and Dr. Barala Kanta Mishra, they write to the IIC saying that after perusal of the histopathological report,
Sudden cardiac arrest.
died of sudden cardiac arrest and natural disease process.
Yes.
Because the magistral inquiry is before this, and this is the last, the medical opinion on the cause of death.
This is 12/9/2010.
Yes,
which is more than 4 months after the death.
But Milads, this is based on the autopsy report and the viscera which were collected right after that. So it's not like there has been a time lag in the collection of, because
there's no question of time lag, sir. We only know the cause of death. That's all.
Yes, Milads.
How do you explain so many injuries in the postmortem report? Blood in the nostrils, swollen scrotum, swollen abdomen, blisters on the abdomen.
Yes, all of these have been examined by the two doctors at the.
But this is so perfunctory. There's two doctors, 1 page, 5
No,
lines.
well, it's before that, page 54 and 55 minutes, they have given that report, and finally, my lords, 56 is.
This is all internal, sir. This is the viscera.
Please, my lords.
It doesn't explain the external injuries that was noticed in the postmortem report. Viscera is only about the internal organs.
Yes, my lords.
Injuries will be on the external part of the body, right?
Yes, but the cause of death is, say that the deceased died of sudden cardiac arrest or natural disease.
Which is what the whole question is. Can this really be called that?
This is somehow a similar case your lordship has decided. It's Purnachandra Mahapatra and others versus state of Odisha, my lord. Irrespective of the offense he has committed, my lord, his rights.
Absolutely. In fact, you accuse somebody of something, then you have to follow the rule of law. Very early on, actually. Sorry, orders reserved. All right.
Weekly list item number 40.
So item number 40, read petition has become infructuous as the order has already been complied with.
All right. Dismissed as infructuous. I'm
weekly list item number 41.
May I please, Your Lordship? Your Lord, the land of the petitioner has been acquired and certificate is issued under Annexure 1. And so far this policy is concerned, it is of 2006 and therein it has been categorically therein it is categorically stated that in clause 8 regarding rehabilitation assistant.
This is Indian Oil Corporation.
Yes, ma'am. The opposite party number 1, 2 and 3.
You are appearing for Indian Oil?
My lords.
No counter, nothing filed, sir.
My lords, it was only on 21st. It has come up to the list, my lord.
Notice is issued, sir, on 6th September.
Let it be on board, my lordship. I just pray. On Monday, my lordship, I will take instruction.
No, you file a counter, sir.
My lords, my lords.
Indian Oil Corporation Limited. Opposite party 2 to 4, 2 and 4.
2 and 4.
Will file a detailed reply, paravis reply to the petition. Within 8 weeks, the state government also, bracket opposite parties 1 and 3, will file a reply within the same period. Rejoined to be filed before the next date. Included in the supplementary list of matters on July 6th.
Item number 42.
My lord, I am for the opposite party, my lord.
Disposed of as infractions. All right.
Lordship, may say interim order stand vacated, my lord.
Yes, interim order.
Item number 43.
May I please, ma'am? In the instant case, my lord, the present petitioner seeks for rehabilitation assistance as the land has been acquired by the OP number 1. Under Annexure 1, my lord. Page 9. The entire land of one Chandra Behera, who is the grandfather, has been acquired, and the petitioner is the.
Who's for MCL? This is Mahanadi Coalfield Limited, right?
They have appeared, my lord. They have appeared.
That's right. Who's appearing for them?
43.
43.
Yes. I am for the MCL matter. I am for the. They have filed the counter, man.
They have filed the counter. They have not given a copy to me, my lord.
You better give him a copy, sir. Like today, I asked my SU to have the copy. Right. We'll stay on board. We'll take a look at the counter. All right.
Oblige, man.
Lordship, keep it to.
Item 44. Sorry, man. This matter is 10 board. It may be called out the next week.
Next week. May I pray a date, my lord?
No,
1 week after.
It is staying on board. That means it may be called.
But tomorrow I'll serve the copy. No.
So today you take the counter.
Yes. I'll ask my SU to serve the copy.
Item number 44.
None appears dismissed.
Item 45.
My lord, in 45, my lord, I need a short adjournment for tomorrow, my lord, to file a debt charge, my lord.
All right, stay on board.
Yes, thank you.
Item 46.
May I be pardoned, my lord? I am the VC, my lord. My lord, this matter is to go to the NCLT, my lord.
All right.
In the meantime, the unit has been closed and it has been referred to NCLT proceeding. I have filed a memo also.
All right, memo is taken on record. Disposed of in terms thereof. Right.
Obliged.
It's connected matter also. All the connected matters.
Item number 47.
But in item 7, I'm praying for a pass. So Mr. Mishra is.
All right.
Can you take next week?
It will stay on board, sir.
Take on board and take next.
Your Lordship, I have also one prayer.
they have filed an affidavit with compliance to section 17B. They have not served the copy. Even I don't have the copy of the brief. I will request my learned senior to serve me a copy.
Yeah, ask him.
Yes.
All right.
Item 48.
May I please, Lord? My lord, here is a question challenge regarding the tariff, my lord, and the cold storage are coming whether the allied agro industrial tariff, my lord. And very in the similar matter, my lord, lordship's own order is there. Lordship, I tell you. The cold storage after the amendment of the fifth amendment, that was whether coming under allied agro industrial tariff, my lord. That has been the challenge. Law and understand upheld the that it's coming under the tariff of the allied agro industrial tariff, and in the similar matter, one is the opposite party licensee. The single judge has upheld that coming under the allied industrial tariff, and this honorable court also. And the connected matter is the opposite party challenge.
Milord, here, Milord, in the connected case, that order of ombudsman has been challenged, Milord. Cold storage, Milord. Milord, the tariff is introduced for the agro-based consumers, Milord. Agro-based consumers, Milord. The agro-based agriculturists will be benefited. For that purpose, OERC has created a concessional tariff, Milord. And that is not applicable to the so far cold storages are concerned, Milord. Milord, that is why, Milord, the petitioner is a commercial entity, Milord, cold storage.
You given him copies of these orders.
Not a copy, Milord. Let it come, Milord. Tomorrow, Milord, we'll give you a dead chat, Milord. It will be convenient, Milord.
Have you read these orders, sir?
No, Milord, I have not seen this, Milord.
First see these orders and then make submissions. All right, tomorrow.
I'm sorry to interrupt in this matter. A similar matter was filed by Mr. Gautam Mukherjee and it was argued before Justice Todapatra just a month back and it has been admitted. These matters can be heard together for.
There's already two orders, sir. Please familiarize yourself with these orders and show them also to that bench. There are two orders on this very issue. Yes.
Obliged.
Yes.
Item number 49.
Your Lordship, on behalf of Learned Senior Advocate N.K. Mishra, I pray for this to stay on board, Your Lordship.
All right.
Item 50.
Much honored.
None appears dismissed.
Item 49, I am there for the opposite party.
Stay on board. Item 50. Item 51.
None appears dismissed.
Item 52.
Same.
Item number 53.
52, none appears for the petitioner, sir.
52, no instruction. Item 52, no instruction.
No instructions.
52, I am appearing for the university.
All right.
Item number 53.
May I please, Your Lordship? Sure, my lord, the counter has been filed by the state, which is, my lord, not to the facts and circumstances of the present case. A counter, my lord, filed in the case of WBC number 15046 of 2013, in case of Gangadhar Das, my lord, is adopted in this writ application. But the fact is completely different. If your lordship will find a lease.
What affidavit? I don't. No counter here. Is there an affidavit filed in this petition? Which affidavit? Which is the affidavit you are referring to?
My lord, in case of, my lord, WPC number 15046 of 2013. It is filed, it is in my counter, my lord, date is given 15/4/2021.
This is 20159. In that they filed a counter.
No, my lord, no counter is filed in this writ application, but a counter has been filed in case of my WPC number 15046 of 2013. That copy has been served upon.
Maybe they served it wrongly. In this, I don't think they filed any counter.
My lord, even if there is no counter, your lordship can hear this matter. I have got the original file also with me. I can hand over the file. Sir, your lordship may kindly have a glance.
No, my lord, my point is, your lordship. Sorry. My case is, your lordship, the lease has been granted in the year on my lord 26/12/74. It is cancelled, my lord, on 11.
14 years theory is
14 years theory, my lord, I had supplied.
14 years theory. For that purpose, I am placing this from the impugned order. What is the?
Your lordship may kindly see, I had also supplied on earlier date that the judgments. Your lordship may kindly see that is dealt with. They say that on fraudulent way, my lord, lease is granted. Your lordship may kindly see page 9.
No, but there are other judgments, sir.
Page 9, my lord. Para 9. I am sorry. Page 8 to 9. Judgment hochi 2012.
2022 re helani.
Further, we find that the original lease was granted long back in the year 1974, whereas the revisional authority initiated so moto revision in 1998 after a long lapse of 25 years. Under second provision to section 7A(3) of the Orissa Government Land Settlement Act, no proceeding can be initiated after expiry of 14 years from the date of order granting lease. While prescribing the period of limitation, the legislature, while drafting the Orissa Government Land Settlement Act in their wisdom,
Here there is there fraud in this?
No, may I respond for a moment? Lord, this is a fit case where the element of fraud is telltale. I'm just placing before a lordship. What is this case? A person projecting himself as a scheduled caste, belongs to scheduled caste community, and he got the benefit, and lease was granted on the basis that he is a scheduled caste person. But subsequently he found that he is not a scheduled caste person. And that is the ground which the ADM has taken note of in the impugned order. And according to my responsible submission, this tantamounts to fraud on the part of the lessee or the applicant.
So that other judgment will apply.
That Asha Hans will apply.
Asha Hans, have you seen that Asha Hans?
You lordship can see this judgment that is dealt with.
No, have you seen the Asha Hans judgment, sir? First ask to see the judgment. It's a later judgment.
This is the latest judgment.
You study that and you make submission tomorrow. You need time to study it. Right.
Item number 54.
And it will be taken up, Malunda.
Stay on board, Roila.
Just staying on board.
Deploy.
Item number 54.
I'm for the opposite party, Malunda.
None appears to the petitioner dismissed.
Item number 55.
55, don't count, though no counter is filed, let it remain on board.
All right.
Item number 56.
Can it be taken up next week?
Yes. It will anyway come up.
Right.
Item 56.
56, 57, my lordship. It may be on board, my lord. On behalf of Mr. Mahanti.
All right.
Item 58.
58, I'm for the opposite party.
None appears to the petitioner dismissed. All right.
I am for the petitioner, minutes. I am for the petitioner. I could not unmute it.
Tell us.
I take liberty of this honorable court to file an FAO under section 24B of the Education
All right. Counsel petitioner seeks leave to withdraw the present petition with liberty to file an appeal.
Under section 24B of the Education Act.
And this, whatever, sir. As per the, as provided in law. If such appeal is filed not later than 17th April, accompanied with an application for condition of delay, explaining the delay on account of the tendency in present petition, be considered in accordance with law by the appellate authority.
Obliged.
Advisor has not expressed any view. All right.
Obliged.
Item number 59.
59 million.
Item 59, your lordship. Your lordship, the conducting counsel, Miss Meera Ghosh, has already expired.
So I may be permitted to appear in these all the cases. Your Lordship, I have only received the 2 Mokalanamas, Your Lordship. So kindly the matter stay on board, Your Lordship. I am collecting other Mokalanama. I am appearing in opposite
What is the
party.
matter about? This is a whole batch, sir. What is it all about?
I am appearing for the opposite party 1, Your Lordship.
You are
Yes, sir, I am
opposite
for the
party.
petitioner,
Yes.
my lord.
Who's for the petitioner?
Yes, I am for the petitioner, my lord.
Tell us, tell us.
Yes, sir, the petitioner challenged the order passed by the presiding officer, Labour Court, Jaipur, my lord. The fact is, my lord, these persons, they have taken BRS. After taking BRS, some years after, they have filed this case, stating that we have not been paid proper amount. For that reason, the matter was heard by the Labour Court, and though he admitted that they have taken BRS and all due, but he has assessed some amount to be paid. The unit has already been closed. The finding is there, the lower Labour Court is also, the unit has already been closed. And the opposite party number 2, 3, and 4, they state ex parte. For that reason, they are not able to lead proper evidence, my lord. However, you will also kindly turn to Annexure 2.
So anyway, you will not be able to pay.
No, my lord, because the unit has been already.
Then why are you worried about filing the petition at all? Why bother filing this petition?
At that time,
closed. What's the point?
Yes, at that time, the one.
There's no stay granted, nothing, sir.
No, yes.
Then what's the point? Why unnecessarily entertain this?
The finding of the Labour Court also that
if your unit is closed, you are anyway not be able to pay the amounts.
No, that's already
that's the end of the matter, sir.
Yes, but
all these petitions have been filed challenging orders of the Labour Court Jaipur in this case under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 about short payment of the dues by the petitioner to the workmen under the voluntary retirement scheme. Stop. Counsel, the petitioner points out that the petitioner unit has long since closed and is no longer operational. Full stop. There has been no stay granted during the pendency of these petitions for over 10 years now. Full stop. In the circumstances, the court sees no purpose at all being served in examining the merits of the impugned orders of the Labour Court. As it seems difficult for the workmen to anyway recover the amounts. Full stop. In the circumstances, while not interfering with the impugned order of the Labour Court, the petitions are disposed.
My name may be recorded.
Yes, yes.
Item number 60.
Diploma.
That's item 60, the state's appeal. Let's may pick it up tomorrow. It had been marked to person who was concerned.
All right.
Sorry. Thank you.
Item 61.
61, I'm praying for a pass over, Lord.
All right.
Item 62.
That appears dismissed.
Item number 63.
I am for the petitioner lordship. Item 63. I am for the petitioner lordship. It is a case lordship against the order of Planning Tribunal, Central District Tribunal, Kotak, rejecting the prayer of the petitioner lordship. Fact remains lordship on a disciplinary proceedings. The punishment is awarded. Page 56, dated 5/10/2007. Running page 66 point, that is the compulsory retirement, Your Lordship. Therefore, prefer the appeal.
Sir, now he's retired, sir.
Your Lordship.
Cross the age of superannuation.
What happened, Your Lordship? Your Lordship, kindly see appellate authority order, Your Lordship. Only appellate authority order. They have given page 102, Your Lordship. 5 punishment are awarded, and lastly, they have stated page 103. Will not be treated as duty and he will receive no pay and allowances for this period, except due pension benefits he has received since his compulsory retirement to end, will receive the same till he joins only. I have joined 25/5/2009, Your Lordship. Since this period has not been paid any pension for the compulsory retirement. That's my prayer, Your Lordship.
Not inclined to interfere. Petitioner's challenges an order dated 28 September 2012 passed by the Central Administrative Court of Cuttack Bench Cuttack and OA number 42 of 2010, whereby the application filed by the present petitioner questioning the punishment awarded in disciplinary proceedings was dismissed. Full stop. Paragraph. While the disciplinary authority imposed the punishment of compulsory retirement, the appellate authority modified the punishment of reduction of pay by 5 stages for a period of 5 years, with effect from the date he rejoins service. Full stop. Petitioner was still aggrieved by the above punishment and therefore approached the CAT. Paragraph. It was argued before the CAT that the petitioner was entitled to back wages from the date of his relief, date of his release on compulsory retirement till the date of his joining service. Full stop. As rightly noted by the CAT, the modification by the appellate authority of the punishment of compulsory retirement imposed by the disciplinary authority was itself lenient, and the question of awarding back wages for this intervening period would not arise, since in any event the petitioner was not performing any duties. The court is unable to find any error having been committed by the CAT in passing the impugned order. The petition is accordingly dismissed.
Item number 64.
None
64.
None of is dismissed.
I'm
the intervener opposite party.
All right.
Ma'am.
Item number 65.
Item 65, there are 3 matters, same, identical. Let's say look to page 38. Similar matter, lots of have disposed of. I am giving the copy. Page 38. Srimant Kumar.
Yes, sir.
Opportunity of hearing. Let's see. This order was passed on 15/7/2013, and the order was, since the petitioner has not submitted document in support of the flow of title from government.
So anyway, Narottam Ratha will apply.
That will also kindly ask exactly this order has been passed.
All right.
And the notice was received on 3/8 and subsequent. Also look to the page 37.
Anyway, sir, it will get set aside.
Right? And I must give an opportunity so that
all that we've said, 3B they can invoke.
Yes, sir.
No, where is this?
Here, but the title of the petitioners has already been established by this unknown.
No, we've passed this order in Narottam Ratha. You have Narottam Ratha. We'll pass the same order. Not this one.
That's it. 7 error case. I've seen that, but this is the exactly case.
It's all right.
That I've got it, but this is exactly this case is similar to my case.
Same result.
Item 66.
6 appear for the petitioner, my lords.
there are two applications, one for amendment and one for substitution. What has happened in the meantime is the petitioner has undergone CIRP, my lords. So these are two formal amendments.
56.
66. Your lordships has allowed amendments in other matters.
Correct. So
similar.
14235.
Chips, counter or instructions, at least from the state government, will be necessary, my lords, in this case.
For the reason stated that 14235, the application is allowed. And the applicant is substituted in place of the petition number 1 company, and petition number 2 is deleted from the array of parties. The schedule appended to the application is taken on record. Then
I'll need to file a consult.
14236. For the reason stated therein, the application is allowed. And the amendments as proposed are permitted to be carried out. Then in the main writ petition, it says the consolidated writ petition be served on council of the state within 2 weeks. Be filed within 2 weeks with copies to be to the council for the state government. List in the supplementary list on 29th August.
Lordship, I am for OP number 6. IDCO, the copies may be served on me.
It will be served on all opposite parties. All
Obligation.
My lords may only observe that the interim order may continue.
Interim order.
Item 67.
Your lordships fixing any date in this matter?
29th August.
29th August. Deeply obliged.
Item 67.
None appears dismissed.
Item number 68.
Narottam Ratha's case.
All right. Narottam Ratha.
Item number 69.
69 also covered by Narottam Ratha judgment.
All right. Yes.
Item number 70.
68.
None appears dismissed.
Item 71.
My lord, 71 annexure 5 is under challenge. That is the hour passed by the labor court in rejecting my claim. The lordship may kindly turn to annexure 5.
You're for the other side?
Yes, ma'am.
Ah.
My lord, find without taking note of any evidence, the award has been passed, page 51. Finding is one para. Hello, may I place that? No discussion, nothing. One paragraph order.
How many of them are still around? How many of these workmen are around?
My lord?
How many are there? Workmen.
Age?
How many?
17. Workmen's number is 12. The 12 in number before your lordship. I'm not getting probably.
Are they still around, madam?
Yes.
The names of those 12 people, where are the names given?
Names have been given in my lord. I have given. That is in the award itself, it is there. Page 44.
How many? What is the age of all these people? Where are they now?
That, my lord, that I have to.
You better find out, my
Your lordship may keep it.
Yeah, it will stay on board. You find out.
Yes.
All right.
Item 72.
Lordship, kindly pass over and take some instruction that we can dispose of next week. Thank you.
Item 73.
None appears dismissed.
Item number 74.
And nothing with the opposite party, number 3.
All right. None appears to the petitioner dismissed.
Item number 75.
Lord, matter may stay on board, my lord. Tomorrow, pass it.
Item 76.
Covered Narottam Rathu.
My lord, second matter, I am appearing, it is also covered Narottam.
All right, 76.
Item 77.
May Pujol. On the petition challenge the awarded 28/5/2013 manner, Annex 2 manner.
My lords, in item 77, the management is before the NCLT.
Then you have to go to the NCLT. The court is informed. The respondent management is before the NCLT, permitting the petitioner to work out his remedies. In the NCLT, the petition is disposed of. Right.
Oblige your lordships.
Item 78.
Yeah, please, your lordship. Lordship, kindly, I am for the opinion about 2, your lordship. Lordship, kindly peruse the last order, sir. Sir.
I am in fact for the petitioner here, for the Padantar Prachar Samiti. I'll request your lordship to let the matter stay on board. I'll take instruction if can be settled out of the board.
All right, lordship. All right.
Item 79.
Item 79 matters, no instruction matters with the leave matters if cause of action survives.
I think so. That leave you always have. No instructions dismissed. Right, we stop here.
Lord, we are appearing in a batch of writs.